Lordship, I wish to mention there is some execution matters in the year of 2019, and after that, this matter not running in the list. Okay, so I'm praying. Actually, the court has given direction for affidavit of asset filing, but they are not yet filed affidavit of asset. So this matter I'm praying for inclusion in the daily list.
My lord, may I have your lordship leave to mention matter? I am praying your lordship kindly, my lord, to file 3 to section 29A applications, my lord. It is typed in the, my lord, not in bond paper, my lord. It's in white paper, my lord.
It
The
has to be in
department
the
is
bond paper.
yes, my lord. Department is not accepting. I am kindly leave, my lord, to file the same with the department, my lord.
No, you have to file it in the proper format, sir.
It is in the format, but bond paper is not there.
So you have to put it in the bond paper.
Let's kindly leave to mention a matter. It's running as item 142. It's a section 34, to which the other side has conceded. There was a injunction during the period of injunction. My lord, they've passed an award. We filed a section 34. We've served notice on the other side. Sinha and company is appearing, my lord. They're representing the respondent. If it can be, my lord, upgraded, it can be disposed of immediately. They've conceded on the last day when, my lord, the matter was taken up. Section 34, Ugro. They're appearing in the matter. Lord,
Yes.
Lordship,
the
it's
same
not
paper, I
by
understand.
team matter. It's by Mr.
It
K.
can be, my lord, listed. They
I
can, my
can
lord.
inform them. I can inform them.
Mrs. Sinha was appearing in the matter, my lord. Very deeply obliged. It's item 142. We have indicated in today's list. Of the monthly list. Of the monthly list. And
So it has been settled or what? What is it?
It's a section 34 to which they'll concede, my lord.
They'll concede.
They'll concede. It's a new appointment which is now required, my lord. If they consent, my lord, concede to the appointment, it can be done in the same proceeding. I'm very
The-
deeply obliged, my lord. Deeply obliged.
Is she there? Yes.
Not me.
Ugro Capital
Ugro Capital.
144 monthly list. 144 monthly list.
142. 142 months.
Yes.
Balotia.
They are saying that it can be settled.
No, it's
Yeah.
not settled.
I mean,
my lord. So section 34
Section
can be set
34
aside.
can be
Award can be set
disposed
aside.
of.
Yes.
Award can be.
Yes, Lordship. Anyway, we were
It's a unilateral award. Or what?
It's a unilateral award, my lord.
anyway we were supposed to file.
During the pendency of section 14, there was an injunction. At that phase, my lord,
We'll
an
keep
award was
it.
passed, my lord.
Anyway,
Very deeply
We'll
obliged.
keep
May I permit you to mention a matter, Lordship? There are some execution matters which were last taken up on September
I've
25.
just allowed all execution. I can't do it. Wait for some time.
My lord, may I be permitted to mention a section 34 application? My lord, I'm aware of your lordship's, my lord, the inclination of not upgrading matters at this stage, my lord. This is item 220 of your lordship's monthly list, my lord. 2011 arbitration, my lord, award passed in 2018. My lord, this is an award regarding an insurance claim which was rejected of the petitioner, my lord. My lord, some precedence may be given, my lord, any day, my lord. That is
Not right now. Not for 34th. Right.
May I be permitted to mention, my lord, this matter has been settled, my lord. This is not running. This has been disposed of. Only what has happened, the amount, there was a direction of this honorable court to deposit some certain amount with the registered original site that has been kept. Now the matter has been settled before the arbitral tribunal, and now direction has been given to take out that money. That is why an application has been taken up in a disposed of matter for taking out that money only. It may be kept on to be mentioned. Matter has been settled.
That has been settled.
Yes. Settlement agreement has also been signed. Only the amount lying with the original site register that has to be released.
lordship.
Disposed in the application file by the GA Company Commercial Division. Diploma.
May I be permitted to mention this matter? This matter was taken up yesterday, as because the service upon the respondent number 2 to 4 was not completed as by the your lordship has directed us to serve it by way of alternative publication. Your lordship, in the meantime, we have traced out the correct address. I was praying for a correction in the order. If your lordship kindly direct us to serve it by way of registered post.
To be mentioned about.
Your Lordship, leave be given to mention 4 execution commercial and 3 AP commercial for withdrawal. Lordship, may I permit to mention a matter for withdrawal? Lordship, actually, the matter I was mentioning before, it was another matters which were last taken up very first time for last
We'll take
2025.
it up. Just let me finish my board.
Okay.
To be mentioned, item number 1.
Your Lordship, I'm on behalf of the award holder. In this matter, the matter has been settled between the parties. We would pray for a withdrawal. In this. This is the instruction. These are the written instructions.
This item number,
1.
learned counsel for the petitioner states that the matter has been amicably settled between the parties. She wishes to withdraw the present petition, the same is dismissed as withdrawn. All interim orders, if any, stands vacated.
Item number 2.
Your Lordship, my appearance has been recorded wrongly in the order. The Miss S. Emma, you see, it has been recorded that I'm appearing for respondent number 1, 2, and 3. It will be 4, 5, 6, and 7. I'll just hand over the
Just hand over
corrected
that
copy of the
and-
order.
Just make the
Much obliged, Your Lordship.
Item number 3.
Your Lordship, in item numbers 3 to 6, the matter has been settled between the parties. We would wish to withdraw this. These are the written instructions.
same as item 1 kar lena. If you want, you can add one line even in item 1. The instruction is taken on record. The instruction to withdraw the writ petition is taken on record. Oh, sorry, the petition execution is taken on record. Submit डाल देना. 1, 3, 4, 5, 6. 6. Same order, same as.
Item number 4.
4, 5, 6 is done. 4, 5, 6 is done. 7.
My lord, we come back to my lord. This was an order passed in the execution application by your lordship on January 9th, 2026.
Order touch.
My lord was pleased to direct the registrar to encash the bank guarantee and pay it to them, plus my also hand over a sum of rupees 10 crores or not, which was lying.
Yes.
My lord, we have since, my lord, I mentioned this matter that day, we
Yes.
have since, my lord, handed over to my learned friend's client a bank draft of 10 crores or not, which covers the entire amount representing the bank guarantee. Let that be recorded.
Lord, kindly come to the last paragraph, page 2. My lord had passed an order for release of proceeds, my lord, which is held by the registrar in terms of prayer A. That remains.
Yes.
But so far as the B is concerned, Lord, your lordship can record that the prayer B is recalled. And Lord, your lordship can record that they have paid, Lord, this amount which was covered by the bank guarantee.
Take
I
down.
have the covering letter with me under
It
which
is,
The matter is-
I've got the main original.
The matter has been taken up on mentioning. This court, by order dated 9 January 2026, had passed these directions. ये tick to tick लो page 2 से. Okay, from here. Till here. The order stands since the awardator has handed over it's a bank guarantee. What
It
is
is
it?
demand draft.
Demand draft of rupees 10 crores 65,72,217.47. The direction contained above is modified to the extent that
Thank you.
the bank guarantee referred to in prayer B shall not be encashed, and the proceeds thereof need not be released to the authorized representative of the award holder, since the award debtor has already handed over the demand draft of the said amount to the award holder. Full stop. The rest of the order shall remain as it is. Yes, sir.
My lord, one thing, my lord, let the bank guarantee stand discharged and let the registrar, my lord, return the bank guarantee to the award debtor. To the award debtor.
The bank guarantee lying before the registrar stands discharged, and the same shall be returned to the
Award data.
award debtor, since the award debtor had already given the demand draft of the said amount.
Much.
And one other thing, my lord has also been pleased to direct us to file an affidavit of assets. My lord has been pleased to grant 2 weeks. Kindly make that 4 weeks, because in the meantime, after they receive this money, I've had a word with Mr. Kaur, my lord. Maybe the amount which is due and payable towards interest can be resolved by mutual settlement. That need not be recorded. Kindly, my lord, instead of 2 weeks, make it, my learned junior says 6 weeks. I leave it to my lord.
Give it 4 weeks for the time being, Lord. If any extension is required, I don't think there'll be any problem.
The order further contains a direction upon the award debtor to file their affidavit of assets within a period of 2 weeks. Full stop. Let the affidavit of assets be filed within a period of 6 weeks.
Grateful.
List after 6 weeks.
Item number 8.
Your Lordship, I appear on behalf of the petitioner. This is my
I'm for the I'm for the respondent in this matter.
arising out of an application filed before the MSME Facilitation Council.
And the page number, there is the copy has been stopped. Page number 15 and 16 are missing.
Orders passed by 2 coordinate benches. One
Catch
hearing
your
a
breath,
sim-
Mr. Satadru.
And the page number 15 and 16 are missing from my brief. That has not been served.
If I like, yes, my lord, there have been orders passed by 2 coordinate benches. One hearing a similar application as the present, where, my lord, the learned single judge hearing the matter said that you have approached the MSME council. Once MSME arbitration is going on, then you can file an application under section 17. But if you at a future point in time, situation arises that the remedy of section 17 before the MSME council is not efficacious, then you can come back. Second, civil revision was filed, my lord, where, my lord, writ petition was filed, where a learned single judge, my lord, directed the MSME council to complete the process within 90 days. Now, despite these 2 orders, my lord, and 14 letters, my lord, which you have written to the MSME council, my lord, the matter is not being heard. Now, my lord, in this circumstance, my lords, my humble submission is, my lord, that section 9 would be maintainable. Because, my lord, despite 2 orders of this court, my lord, the MSME council is not hearing the matter. And, my lord, it is getting either there are no dates, or if there is a date, it is getting adjourned, my lord, at the request of the other side. Now, my lord, I am maybe today at the ad interim stage, but, my lord, my humble submission is that, my lord, let them file their affidavit, my lord, because, my lord, my remedy is I am remediless, my lord, and this is kindly have the orders, my lord. We see the first order. 110. My lord may have 110. I had approached earlier, and, my lord, this is the order which the learned single judge had passed on that instance. This is an application under section 9 of the Arbitration and Conciliation Act 1996. This court is of the view the application is not maintainable, as the petitioner had filed an application under section 18 of MSME Act. At this stage, Mr. So-and-so submits that application be withdrawn with liberty to file afresh. This court is of the view that upon failure of conciliation, Arbitration Act applies. The council or such other institution appointed by the council is to initiate an arbitral proceeding. Upon failure of consideration, then section 18 is set out. Now, kindly see on the next page,
The remedy of the petitioner for interim protection would be under section 17. However, Mr. Banerjee submits that the said procedure may not be efficacious. At this stage, it is not proper to adjudicate on this issue, as there is nothing before this court which would indicate the remedy available in the arbitration proceeding has been proved to be ineffective. Application is dismissed as withdrawn. If at all situation arises which would render the remedy under section 17 as inefficacious, petitioner may approach this court in accordance with law. Now, the other order, my lord, is part of a supplementary affidavit which we have. Copy.
Now, supplementary
Kindly
affidavit has
see, my
not been
lord, my
served to us.
supplementary affidavit. And kindly see the order which your lordship will find at page 6. This is an order, my lord, in WPO 629 of 2025. An application was made by the petitioner for settlement of dispute before Micro Small Enterprises Facilitation Council on 18 July. Petitioner alleges that said reference has not been disposed of till date. Reliance has been made on section 18(5) of MSME Development Act, which prescribes 90 days as the time limit for disposal of the reference. The said time period has long expired. In view of the above, instant writ petition stands disposed of by directing respondent number 3 to take immediate steps in accordance with law with disposal of the reference made by the petitioner at the earliest, but positively within a period of 90 days from the date of communication of this order. 90 days from 27th August 2025. Now, kindly see, I have written, my lord, as many as 14 letters, my lords, several of which have been annexed with the petition and also with the supplementary affidavit. For instance, my lords will see this immediately after this order, because today someone may say that don't show communications before. Kindly see page 8. This is an email, my lord, which has been addressed. And my lord, the order has been communicated. And my lord, a request is made to take up the matter on priority and disposed of within the time frame. And earlier email communications are also annexed. So, my lord, no steps are being taken, my lord. I have in my petition, my lord, made amendments that why I need interim protection, my lord. My lord, whether that is correct or wrong, my lord, let them file the affidavit, my lord. Let them, because today if there is no response from their end on that. Because if despite 2 orders, my lord, MSME Council is not taking steps, my lords, then I have no other.
The writ petition order is to the extent that, the conciliation proceedings prior to the starting of the arbitral proceedings, that has to be concluded with.
No, the arbitral conciliation is already over. Kindly see, my lord. Kindly see, my lord, the order again. An application was made by the petitioner for settlement of dispute. The petitioner alleges said
What is
reference.
happening in the council? They are not hearing your application.
My lord, they are
So it has on 19 December 2025, it has been heard of.
Adjournment, it gets adjourned. I am, my lord, only saying, my lord, that since my section 17 is not being heard, why section 9 may be taken up, my lord. I'm not saying that at this ad interim stage without hearing them, I'm not saying that. My lord may, well, otherwise, my lord, I am remediless.
How is it maintainable?
No, my lord, if during the course of the arbitration, section 9 is maintainable even during an arbitration, but the point is, my lord, I have to demonstrate that I don't have the option of going under section 17. Now, where section 17 is not efficacious, my lord, in that situation, my lord, section 9 is maintainable, my lord.
Yes, madam.
No, my lord, I am virtually appearing in this matter. My lord, I have not received the page number 14 and 15. This is missing from my brief. Whatever is supplied by them. Oh, sorry. Whatever is supplied by them, that is missing.
Blocked. Can't hear him.
My lord is getting.
Mr. Ganguly, I can't hear you.
My lord,
The claim for money, my lord, over 20 lakhs are with interest, it comes to around 35 lakhs.
Where's your senior?
Yes, senior is virtually appearing, sir.
He's logged in again.
Am I audible to my lord? My lord, am I audible?
Yes. Increase the volume.
Volume is very faint.
My lord, am I audible? Am I audible, my lord?
Yes. Yes, you are. Yes.
Yes, sir. Well, sorry. Well, what happened? The page number 14 and 15, what is the brief has been supplied by them that is missing? Number one. Number two point is that on 19 December 2025, the matter has been heard by that authority. And they are yet to pass their judgment accordingly. That is not true that we have made the several adjournment. Never, not a single occasion we prayed for an adjournment before that authority also.
So you are saying on the 19th, the matter has already been heard by the council?
Yes, they were represented on that date.
You please find out, Mr. Sutter.
I'll take instruction.
If the matter is already heard
Yes,
and
yes,
it's
of
reserved for judgment, then there's no point.
Yes, certainly. What are the instructions? Have you? No, my instructions are there. It has been adjourned, my lord. Let him, on what basis?
No, it has been heard of. It has been heard of.
My
They have heard
instruction has been adjourned, saying that section 9 is pending before the
It
honorable.
was adjourned by at their instance.
No
not
hearing
for
has
my
taken place.
instance.
I've got instructions from the client.
Mr. Ganguly, he's saying that no hearing has taken place.
My lord, on that day, I represented my client.
Let him produce some minutes in that. Let him file an affidavit, my lord, in that case, my lord. If he's saying
No problem. It has been heard of on that date.
let him file an affidavit.
No, why should I unnecessarily?
No, I'm saying I have said that it is not heard, my lord. But if he's saying
Is any minutes of the meeting has been passed?
No, but I appeared virtually. They have noted that, but they have asked me that we'll pass our necessary order after going to the brief, entire brief.
Mr. Ganguly, I am adjourning it next week. Please get the minutes of the meeting.
My lord. Well, I did 10, 12 days because I have to apply before them, and therefore they will supply me. So kindly 10 days at least.
I'll give it till next week.
My lord.
We'll have it on the 28th.
28.
28th of January.
My lord. Great.
We'll have it on 28th.
28th?
Yes.
Not
And if it's not there, Mr. Ganguly, you come up with your affidavit that the matter has been heard and judgment has been served. I'm just taking you on face value as an officer of the.
Well, I was there on that
what
day.
you're saying.
My lord.
Outright, that's what court has said.
So even if you are not able to get any reply from them, you file your affidavit.
My lord.
The next date, come up with your affidavit.
My lord.
Most grateful. There's a notice of attorney.
The petitioner has filed the present petition under Section 9 of the Arbitration and Conciliation Act 1996, seeking a direction against the respondent to secure the petitioner's claim of rupees. How much is it? 22?
22 lakhs.
22 lakhs.
So principal is 22 lakhs. The
22 lakhs 60,708.
35 lakhs approximately with interest.
Let's go on the principal.
Principal is 22 lakhs. 22 lakhs 60,706.
Learned counsel for the
8.
For the respondent states that the present application is not maintainable since the petitioner has already preferred an application under Section 17 of the Arbitration and Conciliation Act before the MSME Council. No, but what is it? WB?
Facilitation Council.
Yeah.
West Bengal Micro Small Enterprises Facilitation Council.
Okay. Medium MSME Facilitation Council, West Bengal. Council. Learned counsel for the respondent further states that the council has already heard the matter on 19th of December and has reserved the application for orders. full stop. The said fact is disputed by the counsel
On
for the
instruction.
petition. On instruction, the said fact is disputed by the counsel for the petitioner, who states that the counsel has not heard the application, and that despite there being a direction from this court in WPO 629 of 2025, dated 27th August 2025, to the counsel to decide the reference of the petitioner within a period of 90 days, the said order has not been complied with by the counsel, full stop. He further states that an application under section 9 was earlier moved before this court as AP Com 276 of 2025, which was disposed of by order dated 8 April 2025 as being non-maintainable at that stage, though the order though counsel for the petitioner states that the order itself had recorded that if the situation so arises, which would render the remedy under section 17 of the Arbitration Conciliation Act 1996 as inefficacious, the petitioner can approach this court strictly in accordance with law. Full stop. He states that since learned senior counsel for the petitioner, Mr. Sataduru, states that since the counsel has not passed any orders under section 17 and has not granted any hearing, his remedy, he can't be, the present application under section 9 is maintainable. Full stop. Let this matter be listed on 28th for further consideration. 28th January. 28th, 28. Supplementary affidavit is taken on record. Well, okay.
Number 9.
I beg to appear on behalf of the petitioner. This is my section 9 application. Lordship, the service upon the respondents is not complete. I was praying
Learned
before
counsel
your
for the
lordship.
petitioner seeks and is granted further 2 weeks time to
Lordship,
effect
I
service
was
upon
praying
the-
before your lordship the matter can be listed on Monday. By the time it will be completed, it's still in the transit.
Whenever you effect the service, then within a period of 1 week.
1 week.
Within 1 week. Just after a week. 1 week.
Well, item number 10, I am appearing on behalf of the petitioners, my lord. The service is not complete.
Learned counsel for the petitioner seeks and is granted. How much time? 2 weeks.
My lord, 1 week. It's on transit, my lord. It will be done within 2-3 days. Kindly keeps it after a week.
1 week to effect service upon the respondents. List after 1 week.
Obliged.
Lordship, this is my section 9 application appearing for the first time. The service is done on the respondent. Affidavit of service is already on record. Lordship, this arises from a, Lordship, if this chart could be considered. Lordship, this arises from a loan agreement which is dated 30th of March 2025. Loan agreement starts from page 15 of the petition. Lordship, in page 23 of the petition, there is a schedule where the loan of the loan amount of 28,73,903 has been taken for an asset which is GP 4825 Cowl Chassis. Lordship, and at the
Place of agreement is Chennai.
place of agreement is Chennai, but Lordship, at the end, seat and venue of arbitration is Kolkata. Lordship, they have this loan amount was supposed to be repayable in 58 installments, and they 57 installments, Lordship, and the default has been made on the third installment itself, which is on 5th of July 2025. We have terminated the agreement on 17 December 2025. They have received the termination notice. Our claim and as on date is 31 lakhs and odd. Lordship, I was praying for a receiver to be appointed on the hypothecated asset.
Where's the asset?
Lordship, the asset is near and around South 24 Parganas.
What is it? It's a car.
Lordship, it is a construction asset.
All right, take down. The petitioner. The petitioner has preferred the present petition under Section 9 of the Arbitration and Conciliation Act 1996, seeking appointment of a receiver. Appointment of a receiver for taking possession of the vehicle bearing number GPAI. Registration number लिखना WB33E9332 and then model GP4825. Okay, pending resolution of the dispute between the party. Full stop. It is a case of the petitioner that a credit facility amount of rupees 2873,903 was extended to the respondent by way of a loan agreement dated 30th March 2025 and was to be required to be paid in 58 equated monthly installments, commencing from 5/5/2025 and ending on 5/2/2030. Full stop. Full stop. The respondent committed default from the third installment itself, consequently, the petitioner by letter dated 17/12/2025 terminated the loan agreement and raised the demand of rupees 31,44,318.93. Full stop. Despite such termination and demand, the respondent has failed and neglected to liquidate the outstanding dues, necessitating the filing of the present petition seeking interim protection by way of appointment of a receiver. Full stop. Learned counsel for the petitioner submits that in terms of clause 29, right? 29 of the loan agreement, the dispute between the parties are referable to arbitration, with the seat of arbitration being Calcutta. Full stop.
Now to clause C. 29 clause C. The seat and venue of the arbitration proceeding shall be specified in the schedule.
क्या लिखा है? नहीं, last. (29C) of the loan agreement, the seat and venue of arbitration is to be specified in the schedule. Full stop. The perusal of the schedule attached with the petition marks Calcutta as the seat and venue of arbitration. Full stop. It is further submitted that the loan agreement was executed. This was executed at Chennai, right?
Lordship, it is concluded here, but the place is written in Chennai. The people signed over here.
All right, छोड़ दो. Accordingly, this court has the requisite territorial jurisdiction to entertain and adjudicate the present petition. Full stop. Upon consideration of the pleading and the material placed on record, it is prima facie appears that the respondent has committed defaults in repayment of the loan installments, resulting in lawful termination of the agreement. Full stop. The petitioner, being the secured creditor, has a subsisting contractual and proprietary interest in the hypotheticated vehicle. Hypothetical asset. Full stop. The balance of convenience clearly tilts in favor of the petitioner. Full stop. If interim protection is not granted, there exists a real and imminent possibility of the asset being concealed, alienated, or otherwise dealt by the respondent, thereby frustrating the petitioner's claim and rendering the arbitral proceedings infructuous. Full stop. The petitioner would also suffer irreparable loss and injury in the event the interim protection is denied, as the vehicle constitutes the primary security of the loan transaction, and its continued possession by a defaulting borrower would prejudice the petitioner's right, which cannot be adequately compensated by monetary damages at a later stage. In view of the aforesaid facts and circumstances, and having regard to the existence of a prima facie case, the balance of convenience, and the likelihood of irreparable injury, this court is of the considered view that the petitioner has made out a strong prima facie case for grant of interim relief under Section 9 of the Arbitration and Conciliation Act 1996. Full stop. Accordingly, this court is satisfied that the petitioner has established, in view of the same, in view of the aforesaid, so and so is appointed as the receiver for the purposes of taking possession of the asset, being vehicle bearing registration number जो ऊपर लिखा है ना, registration number and model number. ठीक है. Full stop. The receiver shall be entitled to a remuneration of rupees. This is Calcutta only, right?
It's Calcutta.
35,000.
No.
35,000 in addition to actual out-of-pocket expenses which shall be borne by the petitioner, full stop. The petitioner is directed to depute a competent and authorized representative to assist the receiver.
And
The
Lordship, if
receiver in
Lordship could add
identifying,
police assistance if required.
in locating, identifying, and taking possession of the said vehicle. Full stop. The officer in charge of the concerned police station is directed to render all necessary assistance to the receiver as and when required for effective implementation of this order. Full stop. List the matter after
4 weeks, Lordship.
after 4 weeks for filing and consideration of the receiver's report. The petitioner is directed to take all immediate steps for constitution of the arbitral tribunal in accordance with law and to place the same on record on the next date of hearing. List after 4 weeks.
Lordship, I am appearing on behalf of the petitioner. This is my Section 9 application. Lordship, in this matter, I wish to file a supplementary affidavit. They have filed a title suit before the City Civil Court, which has to be brought on record, Lordship. So,
All right. Why titles?
yes, that's a frivolous
An
application.
order is there.
Lordship, and they have taken an ex parte injunction order.
You have a
That's true. They have already appeared.
Yes, we
Injunction is-
filed a 5 and 8, Lordship.
file a 8. If
Yes.
there's a arbitration clause, then how did you approach the civil city court?
And they have taken an extension also. On the next day, they have taken an extension also. So as on
So
date,
the things for a moment, just received the notice just yesterday. Lord, there is an injunction order is there. They already appeared before the learned court below, and that has not been mentioned in this application.
that's why I'm
Learned counsel for the petitioner seeks and is granted liberty to file additional affidavit to bring on record the fact that the respondent has filed a petition before the city civil court,
Judge.
wherein he has procured a stay, right?
yes. Give me the order.
You have the order?
Yes, I have the order.
Right.
Lordship, this is the order where the stay has been granted
And thereafter the extended.
without due process.
Yesterday was matter already extended.
But I have
Has filed a title suit. That's correct. Title suit number 1525 of 2025
Everything. The last order, madam,
before the city civil court. Full stop.
Okay. It can continue. I know.
That can continue, then this can as well.
Wherein the court, by its order dated 25/7/2025,
Not
had
details of criminal.
granted ad interim order of temporary injunction restraining the petitioner and his men and agents from taking possession of the vehicle bearing registration number WB 19L3746 without due process of law. Let the additional affidavit be filed within a period of
1 week, Lordship, I'll file it.
in a period of 1 week. List after 2 weeks.
1 week.
Additional affidavit in 1 week. List after 2 weeks.
Sure.
Then you don't think that I filed the matter the reply to this or the period of opposition.
We'll see that what reply.
Or fix the
But it's better. When is the matter listed before the city civil court?
last order I 16 February.
16 February, Lordship.
What's the point of keeping it
Lordship,
after 2
that's
weeks?
too long.
Remove your section 8.
That will be moved. It was not taken up. It is supposed to be taken
Till
up.
the
already
time the
taken up.
status quo order is there, we can't pass any order.
No, Lordship. Give me the.
This is our last order, 16th. Date is fixed 16th.
And Lordship, the order says that the injunction application is for us not to take possession without due process of law. Lord, we are taking the due process of law.
No, Mr. Sinha, the problem is if there's an injunction order whatsoever, rightly or wrongly passed.
But what they do is not they obtain an injunction not against me in person.
That's
I
right.
can't personally repossess because they say by using court and in violation of law I'm doing it. So not if you're not doing it, you're approaching the honorable court to take possession of the vehicle through it.
No, you have to get the order vacated also. You have to file your section 8 over there.
But no, that will not stand in the way of your lordship appointing a receiver. In fact, if your lordship takes section 8, subsection 3, once
that will stand in the way of.
Once I have filed section, once I have filed a proceeding under section 8.
If there's a proceeding which is already pending, rightly, wrongly, that proceeding has to culminate into a final order. This way, that way, even if it's illegally filed by them, seeking a title suit, though there is an arbitration proceeding and there's an agreement in existence, still, that has to be disposed of.
The order does not stand in the way of this honorable court appointing a receiver to take possession of the vehicle.
Show me any order where a title suit is pending, stay order has been given, and then still.
We'll come back.
Not possible, Mr.
We'll come back. Lordship gives us some opportunity. We'll come back on the next day.
You come back, but not possible. Not possible. Multiplicity of litigation is not possible. You have to file your section 8, get it disposed of, move an early hearing application, whatever you have to do in terms of the loan agreement which you have, wherein you have arbitration clause.
They will be taken up in February 2026.
2 weeks will not help you.
But we.
You're getting your EMI, the vehicle is with him, 2 weeks is not going to help you. You have to put an end to that litigation.
Lordship not keep, maybe just not examine and come back, not if it's not if that what
when do you want?
Lord,
and my lord, the
that not will not.
No, when do you want?
Not,
after 2 weeks.
Not after 2 weeks, not keep it, not we'll try and satisfy your lordship on this.
One instance, my lord, by virtue of that order, the current payment is going on.
I have seen that. I said that just now. I said you are getting the EMI.
Yes, that does not.
It's there in the order.
Item number 13.
Lordship, this is my section 9 application. Lordship, this also arises from a loan cum hypothecation agreement, and they have also filed an injunction application before the Barashat court. Lordship, the order is at page 36, where the injunction order was till 18th of February 2025. So it is not subsisting as on date.
What is the status?
I shall file an affidavit against the petition because blood over the self-same cause of action. The bank has initiated another proceeding under section 9 that was registered as miscase number 6782 of 2025 Cholamandalam versus Mintu Haldar before the 13th bench at City Civil Court. And there a point was taken by the borrower that section 9 application is not maintainable there because the place of arbitration and the venue of the arbitration is at Chennai. The Honorable 13th bench has heard this matter at length. But on last date was fixed on 9th of this month. But due to the resolution adopted by the Bar Association, the matter was not heard on that particular day. And they have brought the 2 orders from the website. But the self-same property, self-same cause of action, another matter is pending before the city.
Can I get the order?
Sure. So this is
section 9 application, Lord. Section 9 application, I shall file an affidavit. by obtaining the certified copy from the
You have filed a section 9 there.
Lordship, I was
because
not aware of this. I have to take
you
instruction.
take instruction,
Yes, Lordship.
not today. Then you have to withdraw this, madam.
Yes, if that is the case, then we'll do it.
Right. Friday, we'll have it Friday.
Yes, sir. Lordship, this is also my Section 9 application. Lordship, it has been served. Lordship, this arises from a loan time hypothecation agreement.
इसको बुलाना. In the last order, have you recorded affidavit of service taken on record? Okay. Affidavit of service taken on record, despite service, none appears for the respondent. And then write everything. On the top only, everything will be same, just on the top. And then you write what. 14 भी कुछ नहीं. Yes.
Lordship, this arises of a loan cum hypothecation agreement dated 13th May 2023. Lordship, the loan agreement starts from page 15 onwards. The schedule is at page 23, where the seat and venue of arbitration is at Kolkata at the end of the schedule, Lordship. Lordship, the loan amount is 48 lakhs, repayable in 48 installments. The default was on the 14th installment, that is on 15 July 2025. Lordship, we have sent a termination on 10th of December. They have received it. No payment thereafter. Our claim as on date is 32 lakhs and odd, and the hypothecated asset is a Volvo excavator, Lordship, which they are running.
Just give me the details. You have a one pager?
Yes, Lordship, I have already given.
Yes. Same as item 11. Huh? Changes are the loan agreement date, loan amount, all right, the vehicle, registration number and other details. वहाँ पे repayable in 57 installments and this will be 48 installments, all right. Claim amount, termination date, and the total amount. These are the only changes in that order. You try to do it. If you can't do it, I'll do it. Okay. Claim order 11. Only those details will change. Try to use your affidavit of service taken on record. Both. Affidavit of service taken on record. None appears despite service. None appears for the respondent. Okay. And in the same order. Okay.
4 weeks.
Item number 15 and 16.
Lordship, this is that MSME matter of Haryana where the Lordship had cited a judgment on the jurisdiction that MSME Council is only the venue, the seat remains Calcutta. Your Lordship was of the view that the section, until and unless the Section 34 is borne by securing the amount, so Lordship, the maintainability of the Section 34. Item number 16 is the Section 34.
16. 16. Yes.
Here, Your Lordship, my contention is that I only got to know of the passing of the award by way of an email of 6th of May 2025, which Your Lordship will find at page 45. When the respondent issued an email demanding the sum as stated in the award. Kindly takes up page 45. Lordship will find from Rakesh Arora @ Pacific Fire Controls, which is the respondent, to CMD Bridge Roof. That is the petitioner before Your Lordship. Kindly sees the date of the email dated 6th of May 2025. Lordship will see at page 46, the subject says non-payment to Pacific Fire Controls Private Limited, final award by MSME Council. Lordship will kindly see the second paragraph. We approached to MSME Samadhan portal. An online meeting was conducted by MSME Council on 20th of March 2024. The representative of Messrs. Bridge and Roof attended the meeting. Having no response, the MSME Council forwarded the matter to the court of such and such, who passed the order on 18th of July. This is an ex parte empaneled experts report, 18th of July, which is one of the grounds under Section 34. And the same was shared with you. The MSME Council called for a meeting on 12th of March 2025, wherein the law officer from your side appeared. Based on these, MSME Council has issued the final award as enclosed, wherein the amount payable with interest calculated till such and such and compounding interest till the date of payment is yet to be added. So, Lordship, and Your Lordship will find in this email, the award was annexed, from which I come to know. Lordship, this pleading I have also given at paragraph 55 of my application. Your Lordship knows, in terms of Section 31(5), the award has to be served upon the parties. A signed copy of the award has to be served. Kindly takes up paragraph 55. Your petitioner states that the instant petition is within the limitation period as provided under proviso to Section 34.
Where are you reading?
Paragraph 55 of my application.
Page?
That's page 35.
Yes.
Right after the grounds. Your petitioner states that the instant petition is within the limitation period as provided under Section 34(3) of the Arbitration Act. The impugned award has not been served till date on the petitioner, and it was only on 6th of May 2025 the petitioner came to learn of the impugned award through an email dated 6th of May 2025 issued by the respondent to the petitioner. The time to file the petition under Section 34 has not yet begun, since the original award has not been served to the petitioner as per provision of Section 31 of the Act. However, the petitioner is filing the instant petition out of abundant caution for setting aside the impugned award because the same is without jurisdiction, perverse, patently illegal, and such and such. Lordship will kindly see the date of affirmation of my application. Page 39 is the affidavit. 2nd of September 2025.
So you filed on 2nd of September?
Yes, Your Lordship. I got to know about the award in May. I filed it in September. This is within 120 days. Now, Your Lordship will kindly, since my learned friend is, even my learned friend has submitted on the last occasion that even they have written to the MSME Council to ask for whether they have served upon me on or not. And I will also humbly beseech Your Lordship will kindly call for a report whether they have served it on me or not, because I have, my instructions are that we have not received the award from the MSME Council, even in terms of Section 31(5). Now, Your Lordship, they have taken two more points in their while they were addressing Your Lordship on the last occasion, is that I had filed a Section 16 and an Order 9 Rule 13 after the award, allegedly after the award was passed. Lordship, that only goes on to show that I had no knowledge that the award has been passed. Kindly takes up Your Lordship the Order 9 Rule 13 application at page 131. No, 34.
Second volume होगा.
Page 131 of the section 34.
Second volume.
Here, your lordship, just in brief to tell your lordship,
131.
131. Lordship, what the MSME Council had done was they had appointed an empaneled expert for carrying out basically outsourcing the entire arbitration proceedings. And the empaneled expert report was adopted in the award, and the award was passed merely on the basis of that empaneled expert report, which was an ex parte report. Kindly takes up page 131. This, your lordship, will find the heading Application under Order 9, Rule 13 of the Code of Civil Procedure, read with 511 of Haryana MSME Council rules for setting aside the ex parte order and ex parte report dated 18th of July 2024. This is not the award. This is the report. This is because I had no knowledge that an award has been passed. 18th of July 2024, and remaining the matter to back to the learned empaneled expert for adjudication on behalf of the respondent along with supporting affidavit. Now, your lordship, kindly sees when was this filed. Kindly takes up page 133. This was on 9th of April 2025, whereas the impugned award annexed to the email is of 12th of March. I would not have filed a 9th April 2025 application for setting aside the ex parte empaneled experts report if I had knowledge of the award. Since I had no knowledge of the award at that point of time that an award has been passed, I had, in fact, when I was served with a ex parte report, I asked setting aside of that so that you at least hear me and then pass any expert report. Similarly, your lordship, along with this Order 9 Rule 13, I had also filed an application under section 16, which your lordship will find at page 158. So an application under section 16 after passing of the award would not have endured to anyone's benefit. It was only because I did not have knowledge that I had filed this, and only subsequently came to know in May that an award has been passed. Kindly takes up page 158, application under section 16 of the Arbitration and Conciliation Act. If your lordship kindly takes the date of affirmation here at page 167. This is also 9th of April 2025. Page 167, your lordship will find dated 9th of April 2025. Lordship, those two documents in fact go on to show that I had no knowledge of the award. March, allegedly the award was passed. April, I filed this application. May, I get to know that an award has been passed. And this only goes on to show that the award was never served under section 31(5) of the Arbitration Act, if I may place that section 31(5). Kindly takes up section 31 of the Arbitration Act, form and contents of arbitral award. Kindly takes up subsection 5. After the arbitral award is made, a signed copy shall be delivered to each party. Lordship, I am also carrying a judgment. State versus of the Supreme Court. This is the 2011. 2011 4 SCC 616. On section 31(5) to show that it will not be deemed to be served unless a signed copy has been given to the parties. Lordship kindly takes paragraph 12 onwards. Paragraph 12. The appellants are now before this court by grant of special leave. The two provisions of the Arbitration and Conciliation Act 1996 relevant to answer the question raised in the case are section 31 and 34. Section 31 deals with form and contents of arbitral award, and insofar as relevant for the present provides as follows. Here, your lordship, 31(5) has been set out. Section 31(1) obliges the members of the arbitral tribunal or arbitrator to make the award in writing and to sign it. And subsection 5 then mandates that a signed copy of the award would be delivered to each party. A signed copy of the award would normally be delivered to the party by the arbitrator himself. The High Court clearly overlooked that what was required by law was the delivery of a copy of the award
signed by the members of the arbitral tribunal or arbitrator and not any copy of the award. Section 34 of the Act then provides for filing an application for setting aside an arbitral award, and subsection 3 of that section lays down the period of limitation for making the application in the following terms. Section 34 is set out, which thereafter kindly takes up after the set out. The expression party making that application had received the arbitral award cannot be read in isolation, and it must be understood in the light of what is said earlier in section 31(5) that requires a signed copy of the award to be delivered to each party. Reading the two provisions together, it is quite clear that the limitation prescribed under 34(3) would commence only from the date a signed copy of the award is delivered to the party making the application for setting it aside. Thereafter, certain case laws are relied upon. We are supported in our view by the decision of this court in such and such. Paragraph 15 is the last paragraph I want to cite. The highlighted portion of the judgment extracted above leaves no room for doubt that the period of limitation prescribed under section 34(3) of the Act would start running only from the date a signed copy of the award is delivered to or received by the party making the application for setting it aside under section 34(1) of the Act. The legal position on the issue may be stated thus. If the law prescribes that a copy of the order or award is to be communicated, delivered, dispatched, forwarded, rendered, or sent to the parties concerned in a particular way, and in case the law also sets a period of limitation for challenging the order or award in question by the aggrieved party, then the period of limitation can only commence from the date on which the order or award was received by the party concerned in the manner prescribed by the law. So, Lordship, in my humble submission, though my time for filing of the section 34 has not even started, I, out of abundant caution, since I have come to know of the passing of the award, have filed this section 34. Lordship, I also humbly beseech your Lordship to call for a report from the MSME Council Haryana to show whether they have actually served a copy of the award to me or not. Otherwise, your Lordship, I would not have made those two applications if I was aware of the passing of the award. And in fact, even if I was aware, your Lordship, the law requires them to serve a copy of the award. So those are my submissions as regards section 34.
Yes.
My learned friend has said that for abundant caution, he has filed this application. This abundant caution could have been exercised by him much earlier, because the day the award was passed, they had the knowledge about the same order and the award, because they were present when the award was passed. If your Lordship kindly takes the trouble to come to page 28 of section 36 application, they say in section 34 application that they had no knowledge. All right, I will show to your Lordship from the records that that is not correct.
Yes, 36, which page?
36 application, Lordship kindly comes to page 28.
28, yes.
This is the order dated 12/3/2025. Lordship kindly sees the list of appearances. Miss Amrita Sen, law officer on behalf of the respondent. So the respondent was represented. Both the parties appeared before the council. The council has received the recommendation report from the impaneled expert. The impaneled expert has mentioned that the respondent has failed to appear and participate in the proceedings and therefore has proceeded against ex parte. The impaneled expert has recommended that the claimant is entitled to recover an amount of rupees 35,67,071 due against the respondent in respect of the principal amount along with statutory interest, cost, etc. After examining the recommendations report submitted by the impaneled expert, the council listed the matter today on 12/3/2025. The council asked the respondent about their non-participation, but the respondent had failed to provide any justified reasons. It is pertinent to mention here that the representative of the respondent had appeared and participated in the conciliation proceedings held on 23/2024 and were having due knowledge of these proceedings. Despite knowing the same, the respondent had failed to participate and now failed to provide any justified reasons for the same. The council, after going through the case file and report of the impaneled expert, decided to allow the reference filed by the claimant. The respondent is liable to pay the due principal amount of rupees 35,67,071 along with interest as per section 16 of the MSMED Act 2006. The respondent is also liable to pay an amount of rupees 25,000 towards arbitration fee. The claimant is further entitled to receive an amount of rupees 6,000 towards processing fee as mentioned in the award. So therefore, my lord, this document clearly shows that they had the knowledge and they were present when this award was passed or when the award was, my lord, dictated in open court. So they cannot say, as they have stated in page 35 of their section 34 application in para 55, that they had no knowledge. My lord, subject to my lord's kind sanction, it is not correct.
Yes.
And second, my lord, they have to deposit a sum of rupees at least 75,000 before filing this application. 75%.
75%. Not before filing this.
For admission.
So that I am ready to do.
But before that, my lord, in the averments, there is nowhere they have explained as to what happened on 12/3/2025 till the date they have affirmed this application. They say that they have come to know from the very first time when we have emailed them. My lord, that is not the case, as is manifest from page 28. And if this page 28 is to be considered, therefore, when they have affirmed this application, the statutory time period has elapsed.
Yes, sir. You were there, part of that 12th of March. You have participated, but the order had not been communicated. That's your.
Yes, Your Lordship. The order, the award in any event, even if I was present or not present, has to be served in terms of section 31(5), and until and unless that is done, Your Lordship, my time to file the section 34 does not begin. And kindly takes up, Your Lordship, paragraph 36. It is not that of my section 34, Your Lordship. It is not that I have suppressed this. Paragraph 36 of my section 34. I have stated in paragraph 36 that the petitioner, however, upon coming to know of the date fixed, had appeared before the learned tribunal on that date. But Your Lordship, in these MSME matters, Your Lordship will find this was a 352nd meeting. Your Lordship, there are number of matters listed, called upon, Your Lordship, to be the only thing that is stated, award delivered. Even if I was present, the award still needs to be served under section 31(5). My conduct, whether I've appeared or not appeared.
Either we record that they only got to know of the award at the time because there's nothing on record to show, or we ask for a report from the.
My lord, may kindly.
My only humble request is that I'm racing against time. They have filed an execution. I'm ready and willing to secure the amount.
Can't help you with that. Till the time this process is not over, I can't.
That's my humble request.
Nothing can be done. Take down. The petitioner has preferred the present petition under section 34 of the Arbitration and Conciliation Act 1996. Challenging the award dated 12th of March 2025 passed by the Micro and Small Enterprises Facilitation Council, Panchkula, Haryana. Full stop. Learned counsel appearing for the petitioner states that the certified copy of the impugn award has not been received by the petitioner till date. Full stop. However, a copy of the award was transmitted to the petitioner via email dated 6/5/2025 at 22.39 hours. Full stop.
By the respondent, Your Lordship.
By the respondent. Full stop. The petitioner. The petitioner states that the present petition under section 34 has been filed on.
Lordship, my application 2nd of September 2025.
2nd of September 2025. Well within the limitation period as prescribed under section 34(3) of the Arbitration and Conciliation Act 1996. Learned counsel for the petitioner to buttress his argument that he had no previous knowledge of the award being passed on 6th of March 2025, has drawn the attention of this court to the application filed by the petitioner under order 9 rule 13 on this has been filed on
Which is my application.
Yes.
2nd of September 2025.
2nd of September 2025. Full stop. Petitioner further states that he had filed a section 16 application on
9th of April 2020. Your Lordship was referring to the section 16 and order 9 rule 13. Lordship, that is 9th of April 2025.
9th of April, not 9th of April. And the other one also 9th of April?
Yes, yes, Your Lordship.
Had also filed this application under section 16, also on 9th of April 2025. Full stop. It is stated by the learned counsel for the petitioner that in case he would have had knowledge of the impugned award dated 12/3/2025, he would have not preferred these two applications before the council. Full stop. Anything else?
Your Lordship, my only submission that the time under section 34 as per the act has not begun yet.
That I've already recorded.
Very well, Lordship.
These are your contentions. That's
Lordship.
Learned counsel for the respondent
Lordship,
states that the petitioner was well aware of the award passed by the council on 12th of March 2025. Full stop. Which page you had shown?
Also kindly comes to page 27, 28 of the section 36 application.
Yes. He states that the present petition under section 34 is not maintainable since the same has been filed beyond the limitation period. Full stop. He has drawn the attention of this court to the order dated 12th of March 2025, wherein he states that the law officer of the petitioner was present before the council. Full stop. Anything else?
And moreover, my lord, they have not explained anywhere the time period that has elapsed between on 12/3/25 till the day till the date.
They were not aware, sir, so they have not explained.
No, my lord, what I was only trying to submit before lordship is they came to know about this award on the day this award was made, which is apparent from page 28.
It's not, sir. Award has to be communicated. Even if they have participated and the order has been passed, doesn't mean that they are in knowledge of the award. Anything else you want to submit apart from this?
And lordship, they have to deposit 75% to maintain the.
If you agree to that, then I'll allow this.
No, my lord, these were my submissions.
If you want to cut short the entire issue, then I can allow it. I can.
This much only.
All right. Upon consideration, take note. In terms of the argument advanced by the counsel for the parties and the materials placed on record, either I have to call for the report or I can, if you give the concession, I can allow this, because I'm of the prima facie view that they are made aware of the award only by your email.
Also kindly calls for a report so that, my lord,
that will, I don't know when it will come.
So we have no other option. Only if my learned friend would have agreed, it would have.
That will settle all the questions.
Heard counsel for the parties and produce the materials on record. This court is of the prima facie view that the award has not been communicated to the petitioner. Full stop. The fact that the petitioner had moved the applications before the council indicates that the petitioner were not aware of the passing of the final award. Full stop. The petitioner were made aware of the award only through the email which they had received from the respondent on 6th of 25. Full stop. Though this fact is disputed by the counsel for the respondent, hence, full stop. Hence, this court deems it appropriate to seek a report from the, what is this, Haryana MSME,
Yes.
Micro, Small, Medium Enterprise Council, Haryana, to put the controversy at rest. Full stop. In view of the same, the council, you have not made them a party also.
No, Your Lordship.
You have made them a party at least.
Section 30.
I'm passing a direction without them being a party.
Lordship kindly grants me leave then to add them as a party. I'll carry out the necessary amendment.
Make them a party, I'll pass an
The Lordship
order.
can, in any subject to what falls from Lordship,
I'll pass an order.
Lordship, even an arbitrator is a, Your Lordship is
Council,
under the
the-
supervisory jurisdiction.
The such and such council shall place on record the details on which the award dated 12/3/2025 was communicated to the parties. A report shall be filed by the council within a period of 3 weeks. Full stop. Copy of this order shall be provided to the council. Learned petitioner shall communicate a copy of this order to the council. List after 4 weeks. List after 4 weeks.
Should may I file my affidavit of service?
Affidavit service taken on record. First line ही लिख देना. Affidavit of service taken on record.
Grateful, Lordship.
Grateful to your Lord.
Your Lordship, I'm paying for the petitioner. Your
My
Lordship,
Lord, I am for the petitioner, my Lord. My Lord, in this matter, if your Lordship recalls, my Lord, one of the borrowers had died, which was concealed from us. So ultimately, my Lord, we impleted the heirs of the concerned borrower. Now, when the reply was filed, it was indicated to us that one of the heirs, my Lord, a lady, respondent number 6, does not, my Lord, reside with the rest of the family. And that was it. Now, we were unable to serve her, my Lord. Now, my Lord, on the last occasion, your Lordship, my Lord, requested Mr. Shakko, if your Lordship recalls, to provide us with the address of the respondent number 6 so that we could serve upon her. My Lord, now the address has been provided to us just, my Lord, day before yesterday. My Lord, kindly, my Lord, give us a couple of weeks. The address is in America, my Lord. We'll have to, my Lord, effect service upon her in USA. My Lord, kindly give us 2 weeks, my Lord. We'll complete service and come
After
back.
4, then Mr. Lakhwani, let's keep it after 4 weeks, but because it will take some.
Yes, my Lord. As your Lordship, please.
They have to serve the section 9 as well as the section 21 notice on this respondent.
We will do both.
Learned counsel for the petitioner seeks and is granted 4 weeks time to effect service on respondent number
6, my Lord. 6.
Respondent number 6. List after 4 weeks.
My Lord, I was only seeking one liberty. My Lord, there are, my Lord, subsequent documents, my Lord, which, my Lord, are essential to be, my Lord, brought before this court. Since I am getting this 4 weeks time, my Lord, may I use a supplementary? I'll give them a copy, my Lord, to disclose those documents in support of my stand, which I have taken in the affidavit.
We'll see that.
I'll come, my Lord, I'll not serve, my Lord, I'll come prepared with the affidavit just to save some time, my Lord. Grateful, my Lord.
much obliged.
Grateful.
I was being just on time.
They need some more time to
Charge of
effect
the
service on the.
service करा करने. Okay.
He has entered at the right time.
Absolutely, my Lord.
Mr. Sen Malad has used his influence, Malad, so that we Malad get the address. Otherwise, Malad, we were not hopeful about getting the address at all. Grateful.
I am for the petitioner, Lordship.
Then I'll come back and.
Yeah.
What is this item 18?
That
Oh,
is
this is,
the
oh, that, okay.
Kolkata Metro Railway.
Yes, yes,
34.
yes, 34. I'll be back.
Okay.
I'll start from the award itself. Kindly see the finding regarding only claim number 1 and 3 are the subject matter, because those are the two claims which have been challenged. Kindly come to page 55 of the volume 1. 55 is part of the award.
$50.
55. What is the first claim, my lord? The first claim on account of unrecovered additional establishment cost due to extension of phase 1 part of the work. Contract was not originally demarcated into 2 phases, but for the purpose of realignment which took place later, that is why for convenience it has been demarcated as phase 1 and phase 2. Otherwise, it is a composite contract from A to B stretch. For the Shalda to Subhash Sarovar to Shalda.
That map is there, no?
Yes, yes.
770.
They have given in the statement of claim, there is one page where they have given the contract value, how it has changed. Kindly see that also, Lord. It will be. Yes, table. Volume 2 touch. Kindly see volume 2. I'll just indicate that schedule with regard to the page 223 of that volume. There is a chart given.
223.
223.
Yes.
Kindly see, the original contract value was 908.63 crore.
Yes.
Subhash Sarovar to Shalda, Shalda to Central Station. Then descoped from Shalda to Central. 250 crores goes out. Then the revised contract value from Shalda to Subhash Sarovar to Shalda was 657.
Yes.
Then further revised value from Shalda to Esplanade was 621. So ultimately the contract value is 1279 compared to 908. So we will have to consider the contract as a whole. Because of this change of alignment, there was additional contract value which was awarded to you. This is number 1. And now, my lord, what is their case? Their case in claim number 1 was variety of factors not attributable to the contractor. Extension of time was given from time to time. As a result of the prolongation of the work, they have suffered establishment cost in the form of damages. So they are claiming this establishment cost. There are, in principle, my lord, we have given 3 defense to this. First of all, we have said there is a prohibition clause in the contract that if a contract is required to be extended on account of ABC factor, then only for ABC factor your right is unconditional extension of time. I will not be entitled to claim anything from you. You do not have a corresponding right to claim damages. That is first one. But that clause is a part and parcel of the contract. Question will arise whether the arbitral tribunal could have done away with that clause at all. So it will become a question of interpretation of the clause. And to what extent a 34 court will sit in appeal over an interpretation given by the arbitrator. There are some restrictions on that. Only case is that they will have to show that the interpretation given was not even a plausible explanation at all. No reasonable person could have come to that kind of an interpretation as regards that clause. That is the only window which is open to them to challenge an interpretation given by the tribunal. Right. Next defense is, Lord, they have cited several factors for the purpose of delay and extension and consequent mobilization, establishment cost. Now, the contract also says that because of certain employers' requirements, if you have to do certain extra, then you will have to request for an employer's variation. And depending on your request, employer's variation will be allowed. So in this case, I will show the grounds which they had cited for extension. They had given a request for employer's variation. Not to speak of these the part from Central to Shelda. I am only saying even for this so-called phase 1, they had cited certain constraints and they were given a right to opt for an employer's variation. So that employer's variation, they had opted on the basis of their assessment regarding the change in cost and the change in time. So their assessment of employer's variation has been accepted by the respondent employer. So the employer has granted them employer's variation for the factors which contributed to the delay. That is also a specific clause of the contract, clause 23.1. Because I am not suo moto saying that this is the amount you are entitled on account of employer's variation. Employer's variation is dependent upon your assessment. You have assessed the extra cost. On the basis of your assessment, a final decision is arrived at by the engineer that this will be the amount of employer's variation. Now, once that employer's variation has been assessed and determined, then you cannot say for the same factors, I am again entitled to claim additional amount in the form of damages for establishment expense. Because when delay occurs due to CDE factors, A and B being governed by clause 8.3, CDE factors, you have been given the opportunity to assess the cost, additional cost. You have assessed it. You have got the employer's variation amount. 23.1 bars you from now saying that I am in addition entitled to X amount further because of the same grounds. That is number 2. Number 3 is for the project, for the next part of the project, which you say it is the phase 2, the additional work which I have given you as part of this contract. There also, you were asked to quote your price. So when you quoted your price for this phase, so-called phase 2 part of the contract, you have obviously taken into consideration also the additional establishment cost which you will incur and which you have already incurred. So therefore, on these 3 aspects, the tribunal has come to a finding that these claims are already covered in the employer's variation which you have already got, and also covered in the part of the additional contract price which has been awarded to you pursuant to your techno-commercial offer which you have submitted. I have not on my own, thrust upon you this phase 2 part of the contract at the price selected by me. You have quoted it. So on the date when you quote, on that date you have assessed that what has been your loss on account of establishment. And that assessment is part of your techno-commercial offer. These were my line of defense to this particular claim. And I will also show that part of this employer's variation, he had made the claim number 2. Claim number 2 includes this. An entirety of the claim number 2 has been, substantially it has been allowed in his favor. So I will support the finding of the tribunal on the basis of this line of defense which was pursued before the tribunal. Now, in this background, Lordship will kindly come back to the award the finding part. Yes. Page 55. (3.1) Claim on account of unrecovered additional establishment costs due to extension of phase 1 part of the contract. 3.1.1, these are their points. Well, number 1, Roman 1. Claimant presented that extension to completion time of phase 1 part of the work happened due to late handover of hindrance-free work site by the respondent. So first ground he said is handover of hindrance-free work site. I will show from his pleading, this is only one of the instance of the ground of extension. This ground is directly covered by 8.3. Other grounds are covered by employer's variation. That is my case. Then number 2, claimant cited correspondences made during pre-bid conference, and claimant feels that an assurance was given to the bidders that all works are assumed to be ready for possession on the date of commencement of the work. There was already a contractual clause of 2.2 which says that they will be given work site proportionately. Entirety of the work site will not be handed over at one go. That is express provision of the contract. Then kindly see 3, claimant has submitted comparative tabular information show difference between date of handover and actual date of handing over. There is no dispute on that aspect. Claimant has enumerated many factors apart from delay in handover of work site which contributed to delay. So this is what I was saying. Enumerated many factors apart from delay in handover of work site which contributed to delay in completion of works, resulting in need for extension of time. Copies of 4 cases of extension of time were submitted by the claimant for effective extension of time for about 2152 days till February 28, 2019 with regard to phase 1 part of the contract. In all the 4 cases, respondent has granted unqualified extension without levy of any penalty to the claimant. Claimant feels, this is his case, that respondent should compensate the claimant for any cost overrun consequent to delay in handing over work site, etc. Then, my lord, is the computation part. Roman 6 is the computation part. This is the second aspect. Has worked out monthly average actual establishment cost of manpower, machinery, site, transport, etc. at such and such for the period, kindly note this, April 2010 to December 2017 in 1995 months. My lord, additional establishment cost can only arise for the prolonged period of the contract. The computation is made from day 1 of the contract. There is no question of any claim being made from day 1 of the contract. If you are saying that I am entitled to damages for cost overrun, that is only for the extended period. Then, but basis itself is defective. He says from April 10. This is one aspect, and also kindly see, he has estimated monthly establishment cost. So if that is so, this monthly cost he must have considered for the purpose of the techno-commercial offer which he had given. And based on that, he was awarded the contract for the second stage. Claimant submitted all relevant records and documents with regard to such establishment cost before a chartered accountant who has certified the calculation after due examination. This is on Malada. This will be my submission on the computation part. Whether a chartered accountant certificate is sacrosanct. Then kindly see Roman 7. Claimant feels that average monthly establishment cost so worked out should be used to work out compensation to them for the period of extension granted for which the claimant was not responsible. Then, my lord, our submission is he has referred to clauses 8.3 and 8.4 of GCC, which neither permits vitiation of contract nor any compensation for any delay during presentation by the respondent. On 28th and 29th June, the claimant revised their previous stand and submitted, yes, that clause 8.3 is not enforceable. But this submission, this must form the foundation of the pleadings. But if I have to take a stand that this clause is against public policy or this clause is not enforceable of the contract, at the stage when the contract was executed, at the stage when the contract was being worked out, there is no whisper or any reservation expressed about the clause as such. Subject to correction, whether even in the notice of dispute and section 21, this is not a consideration or a dispute that you should not enforce this clause. As it is recorded, it is in the submission. This submission is being made that clause 8.3 of GCC is not enforceable on the following counts. Until a specific right is reserved, the tribunal will be bound by the terms and conditions of the contract. I will show, my lord, from the SOC, this is not their case that 8.3 cannot be worked out and should not be relied upon or enforced. Now, the submission is recorded 8.3 suffers from ambiguity as it does not stipulate outer limit or boundary. The word used in clause 8.3 is unspecified and uncertain. Section 29 of the Contract Act provides that agreement, meaning of which is not certain, is void. Delay is more than 5 years as against contractual period of 4 years. Then, my lord, they have referred to Satyapalan and Suraj Infrastructure. Then kindly see Roman 10. Roman 10 is dealing with the CA certificate and the Hudson formula with regard to computation. Roman 11, in response to question of 80 on idling of resources, manpower and machinery, claimant has submitted that. Well, these are their submissions. These may not be very relevant. Your Lordship will now straight away come to our contention 3.1.2 at the bottom of page 57. From 58, it starts.
Respondent's contention.
Yes, respondent's contention, submitted CSF and sir rejoinder. Page 58, Roman 1. Respondent has agreed that it granted reasonable extension of time to the claimant on their application, as was in the opinion of the engineer reasonable, duly considering the predicament in handing over worksite and other constraints. Respondent has submitted that extension granted on the aforesaid reasons mentioned by the claimant would not vitiate the contract nor entitle the claimant to claim any form of damages in terms of clause 8.4.1, read with clause 8.3, second paragraph of the GCC. Inter alia, the claimant has waived their right to claim for cost overrun on account of delay due to the reasons prescribed. In fact, it was our submission before the tribunal that a contractual right, which is for the benefit of a particular party to the contract, can be waived. Because this amounts to waiver of their general right of damages. Once you agreed and entered into a contract unconditionally without reserving any right, that means this principle of section 73 has been done away with. as per the respondent, claim for cost overrun is expressly contrary to clause 8.3 read with clause 2.2. Respondent has submitted, kindly note this, pleading for claims of delay due to employer's variation, diversion and restoration of chartered utility, removal of unchartered man-made obstruction and other extra work is unwarranted, as contractors are paid extra for such works, which obviously takes into consideration additional establishment cost of the claimant consequent upon the extended time for execution of the variation work. So this I will show, this was my specific case in the statement of defense. As per the respondent, claimant submitted, kindly note this is the next defense, a techno-commercial offer for positive variation of 695 crores to complete the UG2 contract, which includes claimant's establishment cost also, vide their letter dated 28 December 2015. As pointed out by the respondent, the claimant has claimed time overrun of 69 months commencing from April 2012, whereas the Section 21 notice has been issued on 28 August 2018. Therefore, claims prior to 3 years from the date of such notice shall be time barred. Respondent further submits that there was no idling of resources for this delay due to realignment affecting portion from Shialda to Central Station, as the tunnel boring machines deployed by the claimant along with entire logistics and associated resources were allowed to be demobilized after completion of tunneling work from Subhash Sarovar to Shialda as per request of the claimant, and remobilization cost for the same for execution of the realignment variation portion from Shialda to Esplanade was allowed in realignment variation cost. Then, my lord, the judgments we had cited have been quoted. Respondent has objected to submission of synopsis of clarification, adduce further documents in the garb of such clarification at end of the proceedings. Respondent has made the following submission on claimant's response to questions asked by the AT. If mobilization of man and machinery was not made in consonance with the program, it is obvious that the claimant cannot claim the unrecovered establishment cost on that account. There is not a single incident where the consent asked for and denied by the respondent. Rather, the demobilization of tunnel boring machine has been consented and the required charges have also been paid by the respondent. Deployment was not waiting at any point of time. It was also not mobilized at once, but instead it was deployed phase by phase in consonance with the requirements at site. The machines and plants along with technical manpower is often being shared among phase 1 and the realigned portion of the tunnel and the station. Same TBMs were in operation in realigned portion after it was allowed to be demobilized on completion of tunneling from Subhash Sarovar to Shialda. No separate deployment has been done by the claimant at any point of time to construct the tunnel in phase 2. Now, before I go on to the tribunal's discussion, just a few paragraphs of the statement of claim, just to show, my lord, what was their ground which they had taken. Kindly come to paragraph, yes, volume 2, your lordship will see. Yes.
Yes.
You kindly come to page 233. Yes.
Claim 1.
Yes, claim number 1. Claim number 1, your lordship will kindly see paragraph 20. Kindly see page 234 at the top. Particulars of claim vis-a-vis the basis whereof were annexed with the said letter dated February 27, 2018. So they made the claim on February 27, 2018. That your lordship will get in paragraph 20 itself. For the first time, this claim is made for the period from 14 to 17 and for the period from January 18 to December 18, after adjusting the mobilization advance. Then, my lord, next line they say, in response to claimant's letter, GC, this is the engineer consultant, by its letter dated 29th March, requested claimant to submit reasons mentioning the contract clause with details. By subsequent letter, 31st of March 2018, the GC declined to accept the claim on the ground that it is not admissible under clause 8.33 of 3 of the GCC, rejected the same. So this rejection was on 31st of March 2018. Then kindly come to next page, my lord. Paragraph 21. This is where they are saying, though they have not referred to 8.3, this is the only contention which they are raising as regards that 8.3 should not override their statutory claim for damages in the context of a commercial contract. This is the only paragraph. Kindly see, it is respectfully submitted when a breach is committed by one of the contracting parties, the other party is entitled to suitable compensation. This is the settled law. Contention of GC that such claim is impermissible under the terms of the contract is thus not sustainable, inasmuch as the terms of the contract relied upon by GC lost its relevance when the nature of breach exceeds the reasonable anticipation of the parties at the time of conclusion of the contract. Business terms are to be read and understood in terms of business efficacy and not otherwise. Respondent cannot force the claimant to execute contract by absorbing huge financial losses as a result of breach committed by the respondent, which goes even to the root of the contract and renders the contract impossible to perform. But this is the line which they are taking to say that 8.3 cannot be enforced. But there is no, kindly note, this stand is coming for the first time when the claim is arising, not at the stage of execution of the contract. So when I am proceeding with the contract, I am alive to 8.3, that I am given up my right to claim damages under certain situations. When the claim comes and the claim is rejected by the engineer, then it is said that this cannot be the reason because it is overriding my right to claim damages in case of breach. So here, it is not a case where 8.3 has been directly attacked as opposed to section 29 or said that it is unenforceable. So in this context, my lord, it is the question of interpretation of the clause 8.3 by the arbitrator. Next, kindly see another point, my lord, which is very relevant. Kindly see what he is saying here. By absorbing financial loss as a result of breach committed by the respondent, which goes to the root of the contract. My lord, he cannot say that this is the nature of breach which goes to the root of the contract. Any form of breach which is going to the root of the contract gives the right to the non-defaulting party to put the contract to an end. Such provision is expressly in the contract. Even if such provision is not there, section 39 of the Contract Act is there. Because it depends on the nature of the breach. If you treat the breach as fundamental, it cannot be performed. The substratum of the contract has evaporated on account of an act performed by you. Then it is open to me to say under section 39 that the contract stands rescinded by breach committed by you. I put an end to the contract. You have not done it. You have taken recourse to, you have applied for extension. So you have waived the clause, you have waived the right. You have allowed the contract to subsist. You have taken advantage of the fact that if the contract is performed, you stand to gain rather than putting it at an end. So you have weighed your business considerations, opportunity gains, and you have said, let the contract allow, you applied for extension of time. that extension of time was allowed unconditionally. Now, once it has been allowed unconditionally and the employer has taken recourse to 8.3, you are now coming up and saying that I am also entitled to be paid damages and or compensation. You have taken advantage of the clause, so the entire clause will have to be operate. This is, my lord, this is like saying approbating and reprobating at the same time. Now, my lord, kindly see paragraph 22. Paragraph 22, my lord, is the first cause of delay, failure on the part of the respondent to hand over hindrance-free worksite front from Central Station to Subhash Sarovar. This is one of the ground of delay. I will not place this entirety, my lord. Next, kindly come to the paragraph 23 at page 239. These are the other grounds. 23, delay in handing over work from execution of work was also hampered, also due to traffic restrictions. Then kindly come to paragraph, my lord, paragraph 27 at page 241.
In para 23, only traffic restriction.
There are several from traffic restrictions. So that is the coming scope of work site, impediments in the work site. So that they are clubbing it, I am also clubbing it as part of hindrance was not given. The other clauses of impediments which they have categorized is in paragraph 27. At page, kindly paragraph 27 starts, kindly turn to page 242. Page 242, first sentence at the top. As have been pleaded herein before, major cause of delay is the delay in handing over of work site at different locations by the respondent, as a result of which entire planning and sequence of the work got disturbed. Next line. In addition, additional works due to employers' variation, diversion of unchartered utilities, removal of unchartered man-made obstruction, extra work like relocation and construction of additional structure, building facilities, restrictions imposed by local authorities largely affected and contributed to the inordinate delay. Now, my lord, according to our case, all these grounds form part of employers' variation. These, on account of this, employers' variation has been sanctioned in his favor. Kindly now, Lord, let me take your lordship to what is employers' variation. Yes. এটা কোন ভলিউমে পাবে? Volume, this will lordship will get in volume 2 itself, page 184. The clause relating to employers' variation. This is part of SCC, Special Conditions of Contract.
23.1.
Yes, 23.1. Original was subclause 12.3, that has now in the special conditions become 23.1. Employers' variation means a change in employers' requirements which makes necessary alteration or modification of design, quality or scope of works as described by or referred to in the employer's requirements, changes to any sequence, method or timing of construction, manufacture or installations, and changes to any part of the site or work areas or access thereto will not constitute employer's variation. So it is alteration, modification of design, quality or scope of work as per the employer's requirement. So this removal of chartered utilities and unchartered utilities will all come within employer's variation. Now kindly see next paragraph. An employer's variation shall be requested and implemented in accordance with and subject to the following provisions. Number A, within 14 days or such other period as the engineer may allow of the engineer informing the contractor in writing of the intention to request an employer's variation, the contractor shall notify the engineer in writing whether in his opinion employer's variation would, if ordered, give rise to any entitlement to extension of time, affect achievement of any milestone. Number 3 is very important. Give rise to any entitlement to additional payment or affect the warranties of the contractor set out in clause 4.2 of the special condition, and submit his proposal as to the terms upon which he would agree to implement the employer's variation. So when he was requested for employer to notify, he 1, 2, and 3, he was this particularly Roman 3. He has mentioned what will be the change in the price on the cost. Then I will determine, the engineer will determine the amount. Roman B. The engineer shall determine the amount which should be added to or deducted from the fixed lump sum price as a result of the variation, and get it approved by the employer in assessing work covered by any subcontractor. This is not important. So the amount is determined by the engineer on the basis of the proposal of the contractor. Now kindly turn to page 185. In case of any clause E, 185. In case of any variation, once the rates have been finalized by the engineer and approved by the employer, the contractor shall be bound to carry out with the same. No claims shall be entertained by the employer in this regard. So for the other delays which he has mentioned in that paragraph of the statement of claim 242, for that he has applied for employer's variation. Employer's variation has been granted to him. He knows about clause 23.1e. He cannot come under 23.1e. That is why, my lord, the additional claim is being made purporting to turn back on clause 8.3. Now, my lord, as regards this, I'll just show your lordship our pleading with regard to the employer's variation, which has already been granted to him. He does not mention that here. Kindly come to my volume 4, my statement of defense. Volume 4 এ আছে তো। না আমি কাম পেজ আমরা এখান থেকে দেখাচ্ছি তো 518
This is your which document is this?
But this is part of the statement of defense.
Okay.
Kindly come to page 518. As per 518, towards the middle, there is a heading Shielda crossover.
Yes.
As per baseline work program of the claimant, tunneling should have started from Shielda crossover and proceeded towards Shielda Sarovar. Subhash Sarovar, due to some land issue at Shielda crossover, a revised work program was submitted by the contractor for change of construction plan to start tunneling work from Subhash Sarovar towards Shielda crossover. Intended handover dates was revised as per revised work program submitted by the claimant as per modified work plan, which is purportedly concealed in the claim statement to vitiate the reality. Then next paragraph, the contractual recourse thereof due to this change had been settled through a variation proposal EV001, and the respondent has already paid 18 crores such and such to compensate this change. Moreover, to facilitate retrieval of talent boring machines at east end of Fulbagan as per revised work plan, respondent has also paid employers' variation amounting to 6 crore 27. After settling all such matters, the claimant now attempts such and such. Then your lordship will kindly come to page 520, paragraph 23.
Paragraph 23.
Yes.
Yes.
After 6 lines from the top of that paragraph, where the positive statement starts, it is stated that.
Yes.
It is stated that in the event of an employer's variation as defined under 12.3, where it is clearly mentioned that both additional cost and time will be entitled as the employer's variation is a contractual process. Therefore, additional time taken for execution of employer's variation is not a delay within the meaning of contractual terms. Next line, the utility identification diversion of all utilities, chartered and unchartered, is covered within the scope of the work. Claimant hereby attempted to mention the time taken for discharging contractual responsibility delay, which is further denied. Then, lordship will kindly see. Also, when time comes back to page 514. 514. Yes. In fact, so I should start from para 21 at page 512. With reference to allegations contained in para 29 of the statement, stated that UG2 contract was awarded for complete work from Subhash Sarovar to Central for contract value of 908. Establishment cost of the claimant was not for the stretch from Subhash Sarovar to Shialda as mentioned by the claimant, but for the entire stretch up to Central. There was a proposal by government of a change of alignment. In the year 2012, an alignment of UG2 contract was affected from west end of Shialda station to Central station, where the work could not be taken up. The realignment initiative was approved by ministry in August 2015, and the claimant was advised to complete the contract by following alignment from Shialda to Esplanade, including Esplanade station, instead of the stretch from Shialda to Central. Copy of the communication. Then further next line, after R5, further techno-commercial offer was required for this realignment variation to complete the contract, and the same was intimated to the claimant by letter dated 2nd December. A copy of the letter is annexed. Respondent mentions the claimant had the option to serve notice for termination as per clause 13.1, read with clause number 23 capital A, due to this access issue from Shialda to Central. Instead of this move, the claimant submitted a techno-commercial offer for positive variation of 695 crores to complete the UG2 contract along the realigned route, which includes claimant establishment cost also, by letter dated 28 December 2015. Then, well, next page, does the entire change aspect of the contract covering changes in project execution time span as well as scope of work has already been covered by the claimant in the techno-commercial offer submitted, and there is no merit for claiming for further additional establishment cost. On the date of finalization of realignment variation on 8th November 2016, the amount work value of contract scope left in the portion from Subhash Sarovar to Shialda was 62.94 crores, which was only 905% of the work quoted for the realigned portion. Thus, it is imperative that majority of the claimant's establishment cost in the extended period has been involved in the execution of this substantial additional work in the realigned portion, which has been covered in the techno-commercial offer. So this was our third case which we had made out. That when the realignment proposal was given, on that date you already have a claim, so-called claim. So which has been, and you have submitted a techno-commercial offer pursuant to the realignment portion thereafter. Yes. Then, my lord, kindly see the imperative majority claimant extender has been involved in execution of the substantial additional work in the realigned portion, which has been covered in techno as it contained both additional time and additional cost and several other conditions. The techno-commercial offer is negotiated between the claimant and the respondent, both in terms of cost and conditions, and upon arrival of a mutual agreement, realignment variation order was issued for completion of the contract with several new conditions. Therefore, the aspect of additional establishment cost in extended time for execution has already been compensated adequately.
And there is no merit for further claim.
Yes, that is what our case is, my lord. Now, kindly just see one letter. I'll show you, lordship, my lord. They had accepted unconditionally this techno-commercial offer. Yes. Kindly first come to the volume 4 is with your lordship, my lord.
Yes.
Kindly come to page 570.
Yes.
This is the, kindly see the employer's variation submitted by you. Wide letter number such and such dated 6th May 2016 amounting to 621 has been accepted by the authority of KMRCL. So they were asked to submit this just before this letter. So on that date, according to them, they have been suffering additional establishment cost. So that additional establishment cost they had taken into consideration for submitting the higher techno-commercial offer also. Apart from the fact that my case was that you have already been granted employers variation for these works earlier. This is to inform you that design part of employer has already been issued to you amounting to such and such by letter number dated 27 September for item number A1 to A8, for which start date will be considered as date of issuance. Presently, the balance part of employers variation realignment is being issued and comprehensive BOQ is enclosed herewith. This is to inform you that revised contract value is such and such, exclusive of all other variations, price variation, abortive works, and non-scheduled items of work. So this was against 908. Next, kindly see 571. Kindly see the third paragraph of this letter. As no performance bank guarantee has been submitted by you against design part of the said employer's variation as yet, you are advised to submit performance bank guarantee against the total additional amount over and above the contract value. Terms and conditions for this employer's variation communicated by your techno-commercial offer duly reviewed by KMRCL and accepted by you. Wide letter under reference 7 will form a part of the employer's variation is enclosed in Annexure 2. You are hereby requested to take necessary action towards mobilization of resources to take up the above mentioned work forming part of the employer according complete the work within 42 months from the date of issue of this letter. You are requested to submit unconditional acceptance of this variation order within 7 days. Your offer as to rate has been accepted, and now you have unconditionally accepted this also. The details are, my lord, 572 onwards. If your lordship comes to page 574, this figure is the positive employers variation, 621 at 574. And my lord, it is their signature and endorsement is all there at 574. So my lord, with this background, I would like to show your lordship, my lord, now one more very important thing, my lord. So my second part of the submission was that apart from this, they had already been granted an employees variation earlier. This is for the realigned portion. I am saying for the realigned portion also, whatever damages you had suffered as on the date of the approval of the realigned portion, at the time of giving your offer, you have taken it into consideration. Before that, for the previous period, you have already got other employers variation. That is, my lord, this second paragraph of page 570. And, my lord, what is more important is, my lord, if your lordship sees the second claim, the second claim was the employers variation. While granting employers variation, we had granted them for overheads 15%. They had made a claim, number 2, that it should be 20%. Overhead should be 20%. So their admission was that employers variation for phase 1 part of the work I have received 15% overhead. For overhead, it should be 20%. Even that additional 5% has been awarded in their favor, and that amount has been paid to them. So therefore, what I am submitting here before your lordship is this overhead establishment expense they have admitted having received for even the phase 1 part of the work. That your lordship will get in the part where claim number 2 has been discussed. So, my lord, before going to the finding of the tribunal, I just want to place a part of the paragraphs of relating to the claim number 2 where it has been recorded. Page 62, right? Kindly come to page 62. 61 bottom.
61.
Yes, of the award. It is their own case that employers variation I have got, and it's for establishment expense I have got 15%. 3.2, your lordship will see 3.2. This claim is on account of loss suffered due to arbitrary reduction in overhead percentage from 20% to 15% in respect of phase 1 part of the work. Claimant's contention. Number 1, claimant executed many works defined as employers variation as per provisions contained in 12.3, subsequently modified by 23.1, for which it is required to be paid extra for the additional works. Employer is empowered to determine the amount to be added to or deducted from the fixed lump sum price as a result of the variation and obtain approval by employer in terms of clause 23.1b. Claimant has reiterated the provision of clause 23.1e that once rates have been finalized by engineer approved by employer, the contractor shall be bound to carry out with the same. No claim shall be entertained by the employer in this regard. Next one is important. Claimant has submitted that in absence of express percentage of overhead and profit in the contract, the engineer with approval of the employer had been accepting claimant's proposal with overhead and profit as 20%, but the GC on instruction from the employer reduce the margin of overhead and profit from 20% to 15% in determining the price of employers variation after February 2017. So for before February 2017, they have got overhead at 20%. In determining price of the claim, and the claimant has claimed payment of overhead and profit should be restored to 20%. The claimant has submitted value of wage and profit 20% has been approved for variation order EV1 wide amendment order issued by respondent dated 8 November for realignment portion, which is part of the same contract. So, my lord, I need not go into further. So, this part has been awarded. 20% overhead he has got in the award. Amount has been paid to him. So, before February 17, whatever employees variation has been sanctioned to him, he has got overhead at 20%. So, even for phase 1, he is fully covered. His establishment expenses have been fully covered by employees variation and also the employees variation for the realigned portion. And all these grounds which he has cited in the statement of claim, these are all subject matter of employees variation, except hindrance-free work site. Hindrance-free work site has been dealt with on the ground of clause 8.3. So, my lord, now thereafter, my lord, I will come to the finding of the tribunal. This is the case and the counter case. Lordship will now see whether the finding suffers from such grounds as are available under 34.
Too much facts. Mr. Sen has taken me all over the place.
But if reason has been cited, lack of reason, my lord, I have to show your lordship the basics, my lord.
We'll continue after lunch. Finish it.
But there are so many people, but they were waiting for their matter. They had requested, there some other matters are also fixed. Mr. Banerjee, Shatarup Banerjee was there. He says his matter will
That's
go
item
on.
19. Item 19, I think. 18. 18 is this one. When will you finish it then?
Next.
It's already taken so much time.
This is my first day, my lord, on the submission.
Mr. Saha also didn't spare me.
Lordship has taken a very bold step, taking over the 34s.
But we have been trying to dispose it off.
Yes,
No, of
that's what
course.
I'm saying.
I-
That's
and
great.
Greatly appreciated.
Yes,
because
that's what I'm saying.
They were not being heard.
Yes.
They were not being heard.
But give us some freedom also, my lord, so that we can.
Like the Supreme Court, we should have the SOP, take the SOP here also. Put the time.
Time
frame.
allotted.
Time allotted.
Some bench has expressed
But when the
disagreement with that.
Supreme Court's SOP,
that is also now everything is open.
but the Supreme Court's SOP, my lord, I understand, calls for the advocates to intimate to the court what is the time that they require, and of course not to exceed the time frame.
If we do that, maybe we can do more 34s.
Yes, we can.
That is actually possible.
Yes, actually possible.
Hey, when do you want?
Very good.
Monday or Tuesday. Monday can be done.
Monday.
Oh, Tuesday.
Let's do it Monday. Start it.
My lord, Monday I will not be there, but because then, my lord, if my lunch finishes, I will not be able to. Yes. that my lord puts me at ease. My learned friend says with so much.
Can we do it in the second half, my lord?
That I don't know. Let's keep.
Well, Monday, kindly allow me to join virtually in that case.
No problem. Third, learned senior counsel, Mr. Shako Sen, for the respondent list for further hearing. Monday. Let's try to fix it.
Yes.
For judgment, serial number 1, track of.
We'll take the supplementary dispute.
Submission of judgment data, serial number 1,
After this. Give the oath.
नाम अपना
शेख कोफीरुद्दीन
शेख
कोफीरुद्दीन
नहीं
हाँ
शेख फकीरुद्दीन
SKK.
और नाम
शेख बशीर
शेख बशीर और बॉय 37 years বাড়ির ঠিকানা
গ্রামের নাম আছে গ্রাম পোস্ট ভেড়ামারি
ভেড়ামারি ভেড়ামারি ভিলেজ ভেড়ামারি
হ্যাঁ
আর
পিএস পাড়ুই
পিএস পারুই
ফোন নাম্বারটা এক্সচেঞ্জ জেলা বেরোন
ডিস্ট্রিক্ট বিউরো
তিয়াত্তর 12
আমি রাজি 73 12
আমি রাজি মানে উনি রাজি
করেন আপনি
ওই কাজ করি
কি কাজ করেন
ওই রাজমিস্ত্রি কাজ করি
মেসা এমএসও আপনাকে যেদিনকে জজ সাহেব বলবেন সেদিনকে আপনি আসবেন ঠিক আছে আপনার উকিল বাবুতে ওর কাছে একটা ফর্ম আছে ওটা একটা ফলকনামা বলে ওটাতে আপনি ওই ফর্মটাতে ভর্তি করবেন যে আপনার সাবরস্ত কি সম্পত্তি আছে সেটা ভর্তি করে জমা করুন এগুলো যদি না করেন আপনারা কিন্তু জজ সাহেব
করে দেবো
Tell him to file the affidavit of asset. You're appearing?
Yes, Lord.
কি নাম আপনার
আমার নাম শেখ বশির
শেখ বশির আপনার আমার নাম
আমার বাবার নাম হচ্ছে মৃত্যু আব্দুর রশিদ
লেট আব্দুল রশিদ
In accordance with what has been outstanding, it is subsequently a lot of amount. 54 lakhs is outstanding, apart from selling the vehicle that he has taken. So we have a settlement proposal on board. I have taken instruction from my client, but we will discuss it if he is willing to pay.
Communicate to my client and also give them the phone number.
They will proposal to
Lordship.
আপনাকে যেদিনকে বলবেন জজ সাহেব সেদিনকে আসবে ঠিক আছে আর এখানে আপনার উকিল বিভাগের যে ফর্ম আছে
ঠিক আছে
ফর্মটা ফিল আপ করে আপনি জমা দেবেন আমার অর্থাৎ কি সম্পত্তি আছে জমি আমাদের কি আছে সেগুলো সব লিখে ওতে ভর্তি লিখে এগুলো
সামান্য খানিক ভেস্টে জমি আছে হ্যাঁ
যেটুকু আছে
In terms of the order dated 27th November 2025, the award date number 1 and award date number 2 have been produced in the court. Both have been administered. Warrant of arrest discharged. The award date number 1 and award date number 2 undertakes to file their affidavit of asset within a period of 2 weeks.
And they are not residing over here and also they are Mashan. So I need to understand the thing what is and
All right, 3 weeks.
4 weeks Lordship.
3 weeks.
Lordship.
Within a period of 3 weeks. They also undertake to appear before this court for examination or for any other purpose as deemed fit by the court. Let this matter be listed after 4 weeks, 6 weeks.
Much obliged, Your Lordship.
হ্যাঁ কত ম্যাডাম কত দিল 6
Judgment, serial number 1, Srimati Joya Kaur.
In view of the aforesaid, this court holds that the prayer seeking conversion of GA2 into a separate arbitration petition is misconceived and untenable in law, the present application having been filed in a disposed of proceeding and not in the manner contemplated under Section 34 of the Act. The said application is dismissed as not maintainable. It is, however, clarified that this court has not examined the merits of the arbitral award and dismissal of the present application shall not by itself preclude the applicant from pursuing any such remedy as may be available in law, subject to limitation and other statutory requirement. Accordingly, GA2 is dismissed.
May I pray this, man? We have filed, man, the original award along with this, man. Your Lordship kindly direct the department to take back the original award on furnishing this Xerox copy so that we can, that order may.
I'll just add one line in there.
Great.
Just make line add. The copy of the original award shall be returned to the petitioner subject to filing of the certified copy of the Xerox copy.
Grateful, man.
Grateful.
Want to accept? Yeah, same. In view of the aforesaid, nothing survives in the present. Same.
The execution.
Bill number 19. General Manager, Southeastern Railway.
No, this is a section 34 application what I was arguing before, my lord, wherein the amount is secured under 36(2), my lord, for around 264 crores, my lord. Now, my lord, I had shown from the agreements and the documents itself that, my lord, what are the clauses by which the parties were bound with each other, my lord. And there couldn't have been, my lord, any other agreement which could have been acted upon between the parties. So, my lord, the documents I have shown. Now, my lord, as I had said, my lord, I would start with the pleadings, my lord, and the award, so that, my lord, lordship could correlate the same. Now, my lord, kindly, my lord, takes their claim first, my lord, which is, my lord, at page 236 of, my lord, volume 2. My lord, 236 is their statement of claim. My lord, the claims are quoted therein. Kindly sees the first claim. Yes. An award for a sum of rupees 24 lakhs and odd for refundable security as stated in paragraph 56 herein above. So the first, my lord, award that they claim is, my lord, the refundable security amount of 24 lakhs and odd. Then, my lord, an award for a sum of rupees 74 lakhs and odd as stated in paragraph 757 herein above, and annexed to the chart. We'll kindly mark this word because on the basis of a chart, this amount has been given. I'll show, my lord. Annexed to the chart, 74 lakhs and odd. An award for a sum of rupees 59 lakhs and odd, as stated in paragraph 58 herein above, annexed to the chart. So, my lord, charts prepared by the, my lord, litigant, and that is the basis of awarding such amounts. An award for pre-reference interest, injunction, receiver, attachment. So, my lord, there are primarily 3 claims for which they seek an award for. One is refundable security deposit, my lord. One is, my lord, an award for a sum of 74 lakhs, which is in the form of a compensation or damages. I'll show, my lord. And the next one is also the same of 58 lakhs and odd. Now, my lord, let us start with, my lord, the one that is C.
my lord, kindly comes to their, my lord, pleadings at paragraph 58 at page 235, my lord. Page 235, paragraph 58, my lord. The claimant is also entitled to be compensated for the loss of business due to the delay solely attributable to the railways, resulting the construction of the siding enviable and not commissioning the siding consequently. The claimant assesses a sum of rupees 58 lakhs and odd towards such business loss and claims the same. A chart showing calculation of such business loss is annexed here to and marked with annexure C. This is the pleading, and the chart, my lord, I will show. My lord, the chart is at page 241. Now kindly sees the chart, my lord, at page 241. My lord,
Assessment, business loss and claims.
assessed business loss and claims based on movement of commodity as per railway transport clearance letter such and such for the period 1/4 to 2010 to 28 for 2017. So I draw a chart, take a printout, and this is the basis for awarding 58 lakhs and odd. I will show it also, my lord, from the evidence. My lord, my defense wherein I vehemently oppose this and dispute, unheard, not even given, my lord, a deaf ear, and then awarding it in their favor. So a paragraph saying that he assesses. Now the primary and cardinal principle is that, my lord, when I, my lord, claim damages, I have to prove my damages. I just cannot make a chart, my lord, and say I am entitled to 58 lakhs. Because this is loss of business, so I have to show contemporaneous documents to substantiate loss of business for that period. And lordship remembers in the agreement, it is just the opposite. He is supposed to bring in wagons. I am only to give him the siding, of which I will be the owner. It's a leased out property, my lord. It's a license fee which I get from him. So, my lord, I cannot be exposed to any damages unless he can show that, my lord, that amount of wagons of metric tons had come in that month, and thereafter I was unable to give him the siding. Here, it's just the opposite. A litigant comes in, my lord, and files a chart and a paragraph saying that I have assessed 58 lakhs and odd. Therefore, this should be given in my favor in view of this chart at page 241. Now, my lord, kindly sees, apropos this,
But the
whether...
chart says, how have they calculated proposed movement of iron ore?
Yes. Then, my lord, this proposed movement has to be recorded. There has to be, my lord, a receipt book, which is to be signed by both the parties. If I go into that amount of evidence, my lord, it has to be, my lord, there has to be a receipt book. It has to be demonstrated that in terms of the agreement, as I showed, my lord, I think 32 metric tons of, my lord, wagons is to come in every month and go out. Now, my lord, that was there. And even after that amount of wagons coming in, I was unable to provide him the siding. And, my lord, apropos that, he has suffered a business loss. Now, my lord, I have also shown, I will show that also, which has not been even looked into. That is why, my lord, I started, my lord, showing the documents first and then the pleadings and the award, is that there is a notification of the government that, my lord, I am not supposed to pay any damages whatsoever. No claim as far as damages are concerned can be claimed against me with respect to the instant project. Now, my lord, the question is that whether that has been considered in the award has to be looked into. And how has it been dealt with in the award? Now, my lord, the question is that the agreement cannot be rewritten by the arbitrator. The arbitrator has to act within the four corners of the agreement, what is my lord, agreed upon, because the arbitrator is a creature of the agreement. Because I have agreed for an arbitration, that is why he has come. Otherwise, he has got no existence. It's not like a court, my lord. Therefore, my lord, the sole purpose of the arbitrator is to look into the documents and the evidence, how I lay down, my lord, proving my loss of claim. Here, a mere chart prepared by him and a pleading at paragraph 58. That is all. That is all contrary to the agreement, my lord. An amount of 58 lakhs and odd has been awarded in their favor. Now, my lord, it is not that I did not point out. Kindly sees my defense, because there can be an argument that you have never pointed out this. Kindly takes my defense, my lord. Kindly takes, my lord, page 347, volume 3, and kindly comes to, my lord, paragraph 374. Paragraph 35, page 374. My statement of defense starts from, my lord, 347. Kindly comes to paragraph 35. At page 374, my lord.
Yes.
Now, my lord, may I show from paragraph 35 onwards, because there is a specific denial. With reference to the statements made in paragraph 56 to 68, which covers 58 also, my lord, of the statement of claim, this respondent denies and disputes each and every claim made therein, save and except those which are matters of record. All the claims of the claimant in those paragraphs are imaginary, baseless, improper, afterthought, and are devoid of any particulars. So, my lord, I put him to, my lord, a position, making him aware that you have to prove your claim. And I'll show the rejoinder also, my lord. There are also no provisions found under any clause of arbitration agreement in connection with all the imaginary claims of the claimant, and this learned tribunal will kindly deal with the same accordingly. In this connection, the respondent states as follows. It is denied that the value of the land licensed to the claimant by the railways was to be valued at 19.35 lakhs per acre in 2007, 2008, and or the chart showing the year-wise calculation as annexure A in the said claim for the refundable money of rupees 24 lakhs and odd. This I'll show in respect of his prayer A, my lord. Kindly comes to, my lord, this specific one at, my lord, the next page, the second paragraph. 375, my lord, the second paragraph, where I make a specific denial. It is also denied that the claimant is also entitled to be compensated for the loss of business due to the delay solely attributable to the railways, resulting the construction of the siding inevitable, and or railways is liable to pay 58 lakhs and odd towards such business loss as alleged or at all. So I make a specific denial, because the agreement does not say so that I have to pay anything to him. And modifications after one and the other has been accepted by him, since he could not file the plans. Now, my lord, kindly sees, my lord, his response in the rejoinder. That's at, my lord, page, volume, my lord, 4, page 489. My lord, the rejoinder starts. Kindly comes to paragraph, my lord, 52 at page 375. I would have understood after a specific denial is dealt with it, and the arbitrator has taken note of it. Kindly, my lord, comes to 506. 506 at paragraph 52. Kindly sees his reply. with reference to the allegations made in paragraph 35, that's the paragraph I read out, my lord, of the said counter statement, it is denied that the claim of the claimant in paragraph 56 to 61 of the statement of claim are imaginary or baseless or improper or afterthought or are devoid of any particular as alleged or at all. It is denied that there is no provision, my lord, I am just leaving that, kindly comes to this particular claim. There is a sentence starting with to avoid proximity. Lordship has got it.
Yes.
The claimant repeats and reiterates the averments made in the aforesaid paragraphs. It is denied that the railway is not reasonable for non-execution of the siding agreement as alleged or at all. It is denied that railways changed or modified the scope of the work to the extent which was not executable as alleged. It is denied that the siding was not commissioned for lack of initiative on the part of the claimant as alleged or at all. As alleged, or the railway is not responsible for loss of business of the claimant as alleged or otherwise at all. It is denied that railways lost its business in prime location as alleged or otherwise or at all. It is so, my lord, this goes on to my claims. Now, my lord, kindly sees, therefore, there is no attempt even in the rejoinder to substantiate his loss of claim. Nothing, absolutely, my lord. Absolutely nothing except for a chart prepared by him. Now, my lord, kindly sees the evidence. If in the evidence, my lord, one goes and proves his case even, which he has not pleaded, which is otherwise not permissible, still then, my lord, I'll give him the benefit of doubt there also. My lord, kindly comes to 517, volume 4. My lord, it starts, my lord, this is the evidence of Mr. Kollan Kumar Banerjee, which is the witness CW1. My lord, kindly comes to paragraph 71 at page 537. Yes, just one sentence, my lord, the last sentence of that paragraph, of that page, in fact. The claimant is also entitled to be compensated for the loss of business due to the delay solely attributable to the railways, and the claimant assesses a sum of 58 lakhs and odd towards the sum of loss of business loss. This is all. And an arbitrator provides them with a claim of 58 lakhs and odd on the basis of this evidence and this pleading.
Yes.
Now, my lord, kindly see why I say this is contrary to the agreement. My lord, kindly takes now, my lord, clause 4, sorry, page 456. Page 456, my lord, which is the notification under which this agreement has been entered into. Agreement
Policy regarding.
yes, my lord, kindly sees, my lord, clause 4 herein. I have shown this, lordship has marked it, but I wanted to correlate so that it becomes easier for my lord. Page 456 is the notification of 23/10/1997. Kindly takes, my lord, 4. The facilities at page 457, my lord, at the top. The facilities so created would be used not only by the parties who have financed them, but also by others. And the assets so created would belong to the Indian Railways and would be maintained and used as any other railway assets with absolute authority. The investors would not be eligible for any return, concession in lieu of such use of these assets by the railways or other rail users. The investors will not qualify for any preferential treatment in the matter of utilization of these assets. So therefore, my lord, there is no right of return. There is no right of compensation at all. Now, my lord, kindly apropos this, kindly sees, my lord, the agreement, apropos which the arbitration was held, kindly takes, my lord, 4112, my lord, which is, my lord, the earlier, my lord, volume, that's, my lord, volume 3, 412, my lord, which has the clauses of the memorandum of understanding, my lord. This, my lord, is the starting page, which records, my lord, the 22nd day of June 2013 of the agreement. Now, my lord, kindly sees, when I read out 1997, whether it's part of the agreement is 413, my lord, 1.0 general, at the second paragraph at 413, this land licensing agreement for the private siding shall be governed by, the first circular itself is what I read out, 23/10/1997. Now, my lord, kindly takes in that particular agreement clause 6.1. Kindly takes first, my lord, clause 6.1, which is, my lord, is at page 417. Notwithstanding anything contained above, railway administration shall reserve the right, powers, and liberties to close or take over the siding or any extension or part thereof in public interest or at any time without assigning any reasons. Then, my lord, kindly take 6.2. The facilities so created would be used not only by the parties who have finance but also by others. The assets so created would belong to the Indian Railways. Sorry, my lord. And would be maintained and issued as any other railway assets with absolute authority. The investors would not be eligible for any return, concession, lieu of such of the assets by railways or other rail users. The investors will also not qualify for any preferential treatment in the matter of utilization of the assets. Now, my lord, kindly take 6.3. The facility, goods shed, siding, and all its equipment and appurtenances will become the property of the railway administration, and the investor will have no claim to these assets. Investments in such assets will not entitle investors to any rights whatsoever with regards to the railway land on which they are created. So everything belongs to the railways, and he has signed it with open eyes. Now, my lord, kindly takes 9.0, which is, my lord, at page 418. What happens when there is a suspension? Suspension and determination of agreement by the president. Now, my lord, the administration shall at any time and from time to time be at liberty in its absolute discretion to suspend temporarily and or terminate this agreement and all of the privileges hereby granted by upon the expiration of 2 months notice in writing of its intention to do so, being left or sent by registered post to the registered office and address of the licensee, and notwithstanding that the licensee may have executed the work of permanent or temporary character and incurred expenses in the execution thereof. So whatever he might have done, my lord, I have the discretion to terminate it if I, for reasons I, my lord, can do it, my lord. Now, my lord, kindly sees this second part, which is very important. The licensee shall not be entitled to any damage or compensation. Kindly marks it, my lord. Any damage or compensation by reason of such termination or suspension. And I have given a written termination to him, post which the arbitration took place. The rights of the railways shall be absolute and binding on the licensee, and the licensee shall not seek any legal protection against the railway when they are asked to vacate the railway land and initial security deposit is forfeited. Here is a case, security deposit refunded, damages and losses given to him, and he is still enjoying the land which he has not refunded back till today to the railways. And on this, an interest of more than 100 crores has been awarded in their favor. Only interest. This is the award. Without any evidence, without, my lord, any pleadings, without any particulars, except a printout from the computer of a chart against, my lord, the railways, which deals with public money. And this is the agreement. He could not have acted beyond the agreement between the parties. No compensation, no damages. Once terminated, and my lord, he is not supposed to hold on to the land and he should vacate it without any legal process. This is the award. Now, my lord, kindly sees now the award. Page double. Kindly takes the first volume, my lord. Kindly takes, my lord, page 107, my lord. How much is first volume? 3 আছে। Is it 4?
First volume.
Yes, my lord. First volume to be.
এখানেই ছিল তো তাহলে।
এটা তলায় দেখো। Give me one moment, my lord. Kindly takes, my lord, page 107, wherein this is dealt with. Oh, sorry. My lord, kindly takes, I'm sorry, my lord. Paragraph is 107, page 156, my lord. Page 156. এটাতেই নাকি volume 2 তে?
Will be other one.
Yes, my lord, it should be in volume 2, my lord. I'm sorry, my lord. 156 টা কই?
Volume 2.
Page 156. Right to. এটা
প্যারাগ্রাফ অ্যাওয়ার্ডটা দেখুন একদম। প্যাজিনেশন বলেছে আমাদের প্যাজিনেশন।
I think, my lord, my pagination differs with my lord's because it has been paginated later on.
Tell me the para number.
May I just indicate the, my lord, indicate the paragraph number, then it would be easier. বলে দিচ্ছি।
আইপ্যাড মার্ক করো।
এবারটা বলো তো ব্যাপার। This seems to be
প্যারাগ্রাফ
107. Internal page is, my lord, 159/166. Yes, and paragraph 107. Lordship has got it, man.
156.
On account of loss of business, the claimant has claimed a total sum of 58 lakhs in odd. As per calculations made in chart annexed to annexure C of the statement of claim. Assessment of loss made in the said chart is based on movement of goods as per projection and the railway transport clearance dated 25/7/2006 of the railway. This tribunal has closely made scrutiny of the aforesaid annexure. Kindly mark it, my lord. That's a printout. Annexure of calculation and finds the same to be genuine, bona fide, and reasonable for the claims made out of loss of profit of the claimant. No explanation, no reasoning, nothing at all. He finds that looking at that chart, which is the annexure of calculation made by him, it is absolutely correct. No, my lord, discussion as to why. When the agreement says otherwise, my lord, he is coming to a finding, even if I may say, contrary to it. No explanation how, my lord, they have arrived at 58 lakhs and odd. On what basis? Whether, my lord, the compliance of the agreement was at least made by him under the agreement, since he is complaining against me. No finding whatsoever. This is the only, my lord, finding with regard to 58 lakhs and odd awarded in my favor. And on that, an interest of 100 crores. Very reasonable award, I must say, my lord, with greatest of respect. A very reasonable award on a very bona fide claim, my lord. Now, my lord kindly sees this is the only finding in the award with respect to the same. Now, my lord kindly sees there can be a defense. Kindly takes paragraph, my lord, 197. Kindly takes paragraph 97, my lord. What I read out of Mr. Banerjee, Kollan Kumar Banerjee. That's, my lord, internal page 151. Mr. Kollan Kumar Banerjee, senior engineer, since retired, who was directly involved in the claimant's Durga Chowk project, CW1, filed evidence on affidavit affirmed by him on 9th of April 2021. He was examined from 22nd sitting, dated 7/6/2021 to 39th sitting, 23/11/2021, during which 578 questions were asked, to which he deposed. Prior to September 30, 2020, he was deployed in Electro Steel Casting Limited at Holdia and was looking after all the railway siding affairs. He was associated with the railway siding at Durga Chowk. He narrates the gist of the case, date-wise starting from the year 2005 up till construction of siding was ready, and claimant was sending constant reminder letters to the railways for commissioning of the same. He proved the document shown to him, which he marked as exhibit. He explained the contents of various correspondences as well as deposed to the question during a cross-examination. Significantly, no suggestions was given to him to disprove his credibility and the case of the claimant and prove of the case of the respondent. As such, this tribunal fully believes his testimony. That is all. This is what he records. And then the finding, my lord, kindly sees what I read out. My lord, is at page, my lord, paragraph 107.
পুরোটা পড়ে দিতে পারেন আপনি যদি এক্সপ্লেনেশন করার জন্য 97 থেকে আপনার 97 98
97 is this, and then 98, my lord. This tribunal has considered the claims made by the claimant in paragraphs 56, 57, 58 of the statement of claim, and the charts being annexure A, B, and C in support of such averments of claim. This chart that they have put in, my lord, is to be proved by them. How have they arrived at such a tall number? And my lord kindly sees the finding, that's at paragraph 107, with regards to the annexure, which is the chart, and my lord, the amount being given as the claim C in their favor. Absolutely nothing, no explanation whatsoever. No evidence to prove it. Why the arbitrator has, my lord, acted contrary to the, my lord, agreement between the parties. Now, my lord, apropos this, I would like to rely upon on this issue a few judgments, my lord. My lord, the first judgment that I want to rely upon, my lord.
But are your claims over?
This claim is over. This claim is over. Yes.
So for this claim, you are relying.
Yes, my lord, I would do it in that fashion only. One claim, and I will. There are 3 claims, my lord, and the interest part and cost of litigation is also very high here. I think, my lord, koto koti?
ওটা 1 crore
1 crore cost of litigation. Do not look at the other side. None of us were there, I think. None of us. Now, my lord, kindly takes, my lord. The first judgment that I want to rely upon, my lord, is 2015 4 SCC on this issue, page 316. 2015 4 SCC, page 316. No, copy it.
মেইন প্যারাগ্রাফ চাই দুটো আপনি আমাদের
My lord, kindly takes, my lord, the first paragraph with regard to the facts of the case, my lord. 136, sorry. 136. My lord, kindly takes the first paragraph. My lord, the present appeal, that's at page 141, my lord. The present appeal arises out of a public auction conducted by the Delhi Development Authority.
Where are you reading?
My lord, page 141. That's the second paragraph, my lord.
Yes.
To show what was the case
Yes,
before. The present appeal arises out of a public auction conducted by the Delhi Development Authority, wherein the appellant made the highest bid for a plot number such and such for rupees 3.12 crores. As per the terms and conditions of the auction, the appellant, being the highest bidder, deposited a sum of rupees 78 lakhs in odd, being 25% of the bid amount with DDA. This being the earnest money and the terms and conditions of auction, the relevant provisions in the conditions of auction read as follows. Thereafter, my lord, the conditions of the auction are being stated. Kindly comes to paragraph 3. On 18 to 1982, DDA acknowledged the receipt of 78 lakhs in odd, accepted the appellant's bid and directed the appellant to deposit the remaining 75% by 17/5/1982. However, as there was a general recession in the industry, the appellant and persons similarly made a representation sometime in May 1982 for extending the time for payment of the remaining amount. DDA set up a high-powered committee to look into these representations. The high-powered committee on 27/7/1982 recommended granting the extension of time to bidders for depositing the remaining amount of 75%. Based on the high-powered committee report, by a letter dated 18/8/1982, DDA extended time for payment up to 28/10/1982 with varying rates of interest starting from 18% and going up to 36%. Now, my lord, kindly skips the next few paragraphs. Then, my lord, kindly comes to paragraph 9. By a judgment and order dated 2/9/1993, the Delhi High Court held that as the auction was held as per the terms and conditions of the auction, a dispute regarding the same is a matter of contract and cannot be gone into the proceedings under Article 226 of the Constitution. It was further observed on that facts that the court found no force in the contention raised on behalf of the appellant regarding discrimination. An SLP against this order was also dismissed on 16/12/1993 by the Supreme Court, stating that the appellant is at liberty to take whatever steps are permitted to the appellant under the law to challenge the forfeiture of the earnest money, which had been done by a letter of 6/10/1993. This letter is also important for the correct determination of this appeal, and the same is set out here under. Then, my lord, kindly comes to paragraph 11. The paragraph 10 first, my lord. The appellant then filed a suit for specific performance on 17/12/1994 and in the alternative for recovery of damages and recovery of the earnest amount of 78 lakhs and odd. So there was a claim for damages. Shortly after the suit was filed, DDA re-auctioned the premises, which fetched a sum of rupees 11.78 crores. Then, my lord, the learned single judge, by a judgment and order dated 10/9/2007, dismissed the appellant's suit for specific performance and damages, but ordered refund of the earnest money forfeited together with 9% per annum interest. Then, my lord, the findings of the, my lord, learned single judge. Then kindly comes to, my lord, paragraph 12. DDA appealed against the learned single judge's judgment to a division bench of the Delhi High Court. The division bench set aside the judgment of the learned single judge, holding that the forfeiture of the earnest money by DDA was in order. Now, my lord, thereafter the arguments of the learned counsels, I am not troubling my lord, kindly comes to, my lord, paragraph 42. The finding, which is at page 162. In the present case, forfeiture of earnest money took place long after an agreement has been reached. It is obvious that the amount sought to be forfeited on the facts of the present case is sought to be forfeited without any loss being shown. In fact, it has been shown that far from suffering any loss, DDA has received a much higher amount on re-auction of the same plot of land. On a conspectus of the above authorities, the law on compensation for breach of contract under section 74 can be stated to be as follows. Where a sum is named in a contract as a liquidated amount payable by way of damages. Here it's just the opposite. Here, my lord, the parties agreed that they will not be paid any damages. The party complaining of a breach can receive as reasonable compensation such liquidated amount only if it is a genuine pre-estimate of damages fixed by both the parties and found to be such by the court. In other cases, where a sum is named in a contract as a liquidated amount payable by way of damages, only reasonable compensation can be awarded, not exceeding the amount so stated. Similarly, in cases where the amount is in the nature of penalty, only reasonable compensation can be awarded, not exceeding the penalty so stated in the contract, my lord. In both cases, the liquidated amount or penalty is the upper limit beyond which the court cannot grant reasonable compensation. Now, my lord, here is a case where the parties agree that, my lord, under no circumstances there can be any damages claim from the railways, my lord, under this contract. And thereafter, my lord, files, my lord, a compensation chart based on which this is given. Now, my lord, kindly takes, my lord, before I show, my lord, the other judgments, once, my lord, the Contract Act, my lord, copy ache. Section, my lord, 73, my lord, first.
Compensation for loss.
Yes. When a contract has been broken, the party who suffers such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not given for any remote and indirect loss or damage sustained by reason of the breach. Compensation for failure to discharge the obligation of resembling those created by contract. When an obligation resembling those created by contract has been incurred and has been discharged, any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as if such person has contracted to discharge it and had broken his contract. Now, my lord, here is a case where the, my lord, failure on his part by his own document is by a policy of the Union of India, whereby the Union of India says that interstate import of coal is prohibited. So there is no breach as far as, my lord, the railways are concerned. This is a notification which has come out during the pendency of the contract, which disentitled him to import, my lord, coal from another state to the siding. I was to only give him the permission to commission, which I had given. He had changed it several times. I'll show that, my lord, because that's part of another claim. He has changed it several times by way of modifications, which I have accepted. After which, my lord, he could not pay. I terminated the agreement. And there is a contractual obligation to refund the land to me without charging anything. And, my lord, there is no question of damages to be paid to him. So where is the question of, my lord, quantifying a damage as far as I am concerned? And where is the quantification of damage? Now, my lord, kindly takes apropos this once, my lord, 74 also. Compensation for breach of contract where penalty stipulated for. Here, my lord, no penalty was even stipulated. It was otherwise. Even in such cases, my lord, kindly sees what is the law. When a contract has been broken, if a sum is named in the contract as an amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty the party complaining of the breach is entitled whether or not actual damage or loss is proved. So, my lord, he could have come under this only if the contract so provided. The contract otherwise said, my lord, that he is not entitled to any, my lord, compensation or penalty by way of loss. Then comes the question of not even proving it because it's quantified. So therefore, my lord, apropos this, reading 73 and 74, my lord, and there is no explanation whatsoever, my lord, in the award itself, my lord, it is apparent that the entire claim was passed on the basis of complete non-consideration of the documents, complete non-consideration of the evidence, and the pleadings between the parties. Now, the next judgment which I want to show is, my lord, kindly shows sees, my lord, 2009, copy them. 12 SCC, 12 SCC, page 1, my lord, kindly takes, my lord, once the Mr. Sen knows them by heart by this time. My lord, the facts of the case a little bit. My lord, kindly takes, my lord, page 6 of the judgment. Leave granted, heard, learned counsel. The appellants invited tenders for manufacture, laying, testing, and commissioning, somewhat the same, my lord, contract as ours, of a water pipeline of a length of such and such kilometer under a water supply scheme in Ajmer district. Tenders were received from various tenderers, including the respondent. Then, my lord, kindly sees paragraph 2. As different tenderers had stipulated different terms and conditions, the tenderers were invited for discussion and common terms of reference were formulated on 22nd to 1988. And the original tender conditions stood modified to the extent of the alterations in CTR. Thereafter, offer of the respondent was accepted and work order dated such and such was issued to him, stipulating the period for completing the contract as 2 years from that date. There was an amendment to the work order on such and such. Then, Malal kindly takes 3. The employer and the contractor entered into an agreement, just like ours, enumerating and stipulating the documents which will form part of the contract and the modifications agreed to in regard to certain terms. The value of the work as per work order was 9 crores and odd, which was agreed to be released as mobilization advance. Now, my lord, kindly comes to, my lord, the dispute part, and kindly, my lord, comes to, my lord, paragraph, my lord, 8. Page 8, my lord, paragraph 8. In the meanwhile, the contractor filed a suit against the appellant in the district court Ajmer and obtained a temporary injunction restraining the employer from imposing liquidated damages. The contractor made an application to the district court Ajmer under section 20 read with section 8 of the Arbitration Act of 1940 for filing the arbitration agreement into the court and seeking appointment of an arbitrator. Then, my lord, kindly skips over, my lord, and comes to, my lord, paragraph 12 once. After considering the claims and counterclaims, the learned arbitrator made an award on such and such. He rejected such claims. He awarded the following amounts to the contractor to the remaining claims. Now, my lord, kindly straight away comes to paragraph, my lord, 52. 11 11. Kindly comes to paragraph 52, my lord, which is, my lord, at page, my lord, 20. We may also refer to another aspect. A sum of rupees 12,072 per day was claimed as damages by the contractor in a 2-line calculation. Kindly mark 2-line calculation without any supporting evidence or document. As noticed above, the claim was on the basis that the contractor would have manufactured 15 pipes per day of the value of rupees 1 crore 20 lakhs, and the profit and overhead element of it would have been 15% or 18,000 per day. In our case, my lord, it was 32 metric tons of wagon which was to come in per month. Then by taking the working days as 306 in a year and deducting 20% of labor component, the loss of profit per day was calculated to be 12,072 per day. No calculation of this sort, my lord, in the documents filed before my lord. Nothing of this sort. There is no evidence to show that the contractor was at any point of time manufacturing 15 pipes a day of the value of rupees 8,000 each, or that he would have made a profit of 15% on the cost thereof. Identical to our case, my lord. The claim is made out on the ground that it is disabled from manufacturing that many number of pipes elsewhere. Now, my lord, kindly comes to 50, my lord, 3. There is no evidence that the contractor had other contracts where it was required to manufacture that number of pipes, or that it could not manufacture the required pipes for want of plant and machinery. Nor there is any evidence as to the value of the plant and machinery that had been mortgaged to the employer, and what would be the cost of an alternative plant with a capacity to manufacture 15 pipes per day. If the plant and machinery was of the value of, say, rupees 25 lakhs, or if the contractor could install another similar plant at a cost of rupees 25 lakhs, then the loss at best would be interest on rupees 25 lakhs and not anything more. In fact, even though there is no evidence, while making claims 36 and 37, that contractor has given value of the plant and machinery as rupees 36 lakhs and odd, even assuming the said figure to be true, at best the blocked up investment was only 36 lakhs and odd, and the loss would be around 1% per month by way of interest, which would be 36,000 per month. What is more strange is nowhere in the award the arbitrator considers the validity of the claim of rupees 12,000 per day, nor accepts the same claim as valid or correct. In our case, my lord, nowhere in the award the contractual obligation is recorded, which he was to, my lord, fulfill under the contract, and that he has, and apropos that he is entitled to a loss, my lord, for business. In a reasoned award, if the claimant of a contractor is equated to a proof of the claim, then it is obviously a legal misconduct and an error apparent on the face of the award. While the quantum of evidence required to accept a claim may be a matter within the exclusive jurisdiction of the arbitrator to decide, if there was no evidence at all, and if the arbitrator makes an award of the amount claimed in the claim statement merely on the basis of claim statement without anything more, it has to be held that the award on that account would be invalid. Suffice it to say that the entire award under this head is wholly illegal and beyond the jurisdiction of the arbitrator and wholly unsustainable.
So for your one claim, this is over.
There is 2 more judgments I want to show, my lord.
Similar lines, then you just hand it over.
Yes, I will just, my lord, hand it over and refer to, my lord, the paragraphs of the Supreme Court only, my lord. My lord kindly takes it. It's a question of the damages, of course. Now, the next judgment is of 2023, SCC Online, Supreme Court 1366. This is under the new act even.
Paragraph?
Paragraphs, my lord, I just refer it. Paragraph 7, 8, 13. Copy. Lord, if I may just show it little quickly, my lord.
Paragraph 19 to 20 main, but
my lord, kindly, my lord, the facts of the case are, my lord, Lordship will get it at paragraph 7, 8, 13, 15. Kindly takes, my lord, paragraph 19 and 21. None. That is why I did not name the honorable court, my lord. I never do that. The law, Lordship has taken 19, my lord. Before that, the facts of the case are there. So I am only showing the law as it has been laid down. The law as it stood stands thus, is that for claims related to loss of profit, profitability or opportunities to succeed, one would be required to establish the following conditions. First, there was a delay in completion of the contract. Second, such delay is not attributable to the claimant. Third, the claimant's status as an established contractor handling substantial projects. And fourth, credible evidence to the substantiate the claim of loss of profitability. There is nothing, none of them, not even the last one. Then, my lord,
You will go
on
with
a
the fourth.
yes, my lord.
You'll go with the fourth. We are satisfied with the fourth.
Yes. Now, my lord kindly sees, on perusal of the records, we are satisfied that the fourth condition, namely the evidence to substantiate the claim of loss of profitability, remains unfulfilled in the present case. But I have a case where all four are unfulfilled. Now, my lord kindly takes 21. The first award was interfered with by the High Court for the reasons noted above. The arbitrator, in view of such previous determination made by the High Court, could have granted damages to the appellant based on the evidence on record. There was, so to say, none of which on proof could have translated into an award for damages towards loss of profit. A claim for damages, whether general or special, cannot, as a matter of course, result in an award without proof of the claimant having suffered injury. And there is no injury which is being referred to or shown in the records. It is the arbitral award in question, in our opinion, is patently illegal, and that it is based on no evidence and is thus outrightly perverse. Therefore, again, it is in conflict with the public policy of India as contemplated by Section 34(2)(b) of the Act. And this is also under the new Act, my lord. And the last one, my lord, on this, kindly takes, my lord, 2024 2 SCC, page 375. Obviously জানবে রোজগার তো একই দেখা এদিক থেকে এখন ওইদিকে আছে. Kindly takes, my lord, the paragraphs which, my lord, facts of the case would be revealed. Paragraph 23, 24, 25. 28, 40, 45. Kindly takes 47 once, my lord. Kindly sees 47. That's at page 410. We have extensively analyzed the award, its patent flaws and illegalities which emanate from it. Like the manifest lack of reasoning in arriving at the conclusions and the calculations of amounts awarded, which in fact amount to double or part double payments, beside being contradictory. In view of our aforesaid reasoning, the award has been rightly held to be unsustainable and set aside by the division bench of the High Court exercising jurisdiction under Section 37, read with Section 34. And I can show, my lord, paragraph 40 and 45. My lord, if lordship kindly takes it once. That's at page, my lord, 406, which deals with, my lord, saw pipes. Nevertheless, the decision in saw pipes case holds that mere error of a fact or law in reaching the conclusion on the disputed question will not give jurisdiction to the court to interfere. However, this will depend on three aspects: whether the reference was made in general terms for deciding the contractual disputes, in which case award can be set aside if the award is based upon erroneous legal position. This proposition will also hold good in case of reasoned award, which on the face of it is erroneous on the legal proposition of law and or its application, and where a specific question of law is submitted to an arbitrator, erroneous decision on the point of law does not make the award bad unless the court is satisfied that the arbitrator has proceeded illegally. Now, my lord, kindly takes apropos this 45, because thereafter the judgments have been dealt with. Kindly takes 45 months. Referring to the third principle in Western Gecko, it was explained that the decision would be irrational and perverse if it is based on no evidence. My lord, kindly marks this at page 45, paragraph 45. It is based on no evidence if the arbitral tribunal takes into account something irrelevant to the decision which it arrives at, or ignores vital evidence in arriving at its decision. So either way, my lord, the standards prescribed in the state of Haryana versus Gopinath and Sons and Kuldeep Singh versus Delhi Police should be applicable and relied upon as good working tests of perversity. It has been held that apart from the cases where a finding of the fact is arrived at by ignoring or excluding relevant materials or taking into consideration irrelevant material, the finding is perverse and infirm in law when it outrageously defies logic as to suffer from vice of irrationality. Kuldeep Singh clarifies that a finding is perverse when it is based on no evidence or evidence which is thoroughly unreliable and no reasonable person could act upon it. If there is some evidence which can be acted and can be relied upon, however commendous it may be, the conclusion should not be treated as perverse. Here, my lord, I've shown there is no evidence at all. This court in Associate Builders emphasized the public policy, and then, my lord, it deals with how, my lord, it can be, my lord, set aside under section 34. Now, my lord, that is the first, my lord, claim that I deal with, my lord. Then, my lord, I come along with the second claim, my lord.
Second will be on
We
the
have
second.
we have a 3:30 today, my lord.
When do you want?
My lord, I will take a little time more, my lord. I have two more claims and the interest to show. So gives me any day lordship pleases, my lord. I have no issues.
Monday?
Monday?
Monday afternoon.
19th. Yes, Monday, my lord. Great.
Heard. Mr. Banerjee, for the petitioner. Keep it for further hearing.
Grateful, ma'am. Monday.
Your Lordship, I'm led by Mr. Umesh Prasad Singh, Your Lordship.
Yesterday, your lordship wanted that list of dates, etc. We have prepared it.
Yes.
That your lordship will see the reason for delay in hearing of this application. Your lordship. Earlier is not at page 2, your lordship will see
Yes.
the fourth date on 6th of October 2023, the REIT application was decided, my lord.
Let us come on the 34 first. Then we will
Yeah,
move.
that is, my lord. On
4 is
page
757.
757, my lord. Omitting other dates for the present, your lordship will see at page 2, my lord. Fourth date, we had not filed a REIT application during that COVID period. That was disposed of on 6th of October 2023, my lord, fourth day.
Hey,
Giving liberty to us to file it 34th petition.
Just a minute. Just a minute.
Omelette.
6th of October 2023, writ petition order is at page 29 in the section
Justice
34.
Bhattacharya's order,
Justice Bhattacharya's order.
where he had given that limitation.
Liberty.
Was, yes. Then what happened?
Then we had filed a section 34 within the week, Your Lordship, and we had also filed a GA1 for condonation of the
That
deed.
was the order of 6th and you filed it on the 13th, right?
Your Lordship, on of September 2024, Justice Bhattacharya in the AP GA1 had given an order in our favor. That was affirmed by Supreme Court as well, because the other side had gone till appeal, and that was affirmed by the Supreme Court. So the delay part has been decided by this court, Your Lordship.
Really? Delay to...
I mean, you wanted to deposit, be heard 34 without deposit of the money.
Your Lordship,
That's the
that
application.
also-
That's
their application.
Your Lordship, to that also,
May
we
only
had, I'm making my submissions. To that also, Your Lordship, we had said, it had fallen from Honorable Justice Moushumi Bhattacharya that give calculations. Both parties were directed to give calculation.
Yes.
As per MSME, it is mandatory that the award holder has to give an interest calculation. That was not given. Only when I'm making my submissions, you will be given a chance, I am sure. when Your Lordship, thereafter, only after filing of Section 34, pursuant to orders passed by this court, the calculation was given. Thereafter, because they preferred an appeal, two appeals were preferred. From the writ petition, they preferred an appeal before the division bench. From the order passed on 6th of September, they had again preferred an appeal that went till Supreme Court. So on their instances, the matter was adjourned. Meantime, our GA2, which is for exemption waiver of the amount, was pending, Your Lordship. We had offered that we will deposit the money, but there was no order passed by this honorable court. And until unless later on our GA2, there was a hearing done, they had taken a preliminary objection that 34 is not maintainable because under the MSME Act, pre-deposit has to be made, then only 34 can be entertained. Your Lordship, the then bench was pleased to hold. In the hearing, it was argued on our part that there is no system in our High Court that we can deposit the amount. Your Lordship, when the matter was, when it was had fallen from Your Lordship that we should deposit it with the registrar, we visited the registrar's office ourselves. We also presented this letter before the registrar stating that there is no formal order. However, it has been observed by the court that we should deposit it and then only we should come before the matter. Yesterday, we had personally gone to the registrar's office. The registrar said that because the amount is, there is no order passed from the honorable court, we are unable to take the deposit. Your Lordship, this has a stamp of the registrar stating that we visited the registrar's office. And
how much is the amount?
As per our calculation, it is 1 crore 80 lakhs plus amount, Your Lordship. We have also shared the calculation, Your Lordship, with my other side, and this is my calculation. How I've already served on email the calculation.
2 crore 82, right? 75%. This was communicated to them, right? Not right. Hmm.
This is whose calculation? Yours?
This is my
Our calculation is below 2 crore 82 is the amount. We've given them this calculation on 6th of January 2026. This calculation is till November 2025. Amount is 2 crore 82. About 75% thereof is 2 crore 11 lakhs. 59,506. If they want to make this deposit now, my lord. In fact, it has increased. This is the calculation of November, my lord.
According to you, the calculation is 2 crores 10 lakhs.
10 lakhs, Your Lordship.
Look
Because
at this. Your Lordship, Lord, by kindly one thing. The Honorable Supreme Court says on the date the appeal is to be preferred, that is the date relevant. He had, my lord, offered on 22nd of November 2023 itself. But delay is due to reasons, my lord, that they had gone in appeal, then thereafter second case. We had, my lord, that is the date, my lord, relevant. On 6th of October, even 24, we were ready to deposit. They objected.
When did we object?
That is your lordship will find from the order of this honorable court, my lord. On 22nd of November 2023 order, your lordship kindly see.
Yes, 7th of December. Not now.
First, my lord, we offered, my lord, that it was taken up 22nd of November 2023, my lord. When 93 lakhs draft, we were ready to.
December. It's the 7th of December order. Not November, December.
No, your lordship will pardon me, Lord. The first is the date, 22nd of November 2023, my lord. But when this was taken up, your lordship kindly see you.
One line order lists the matter along with AP 758.
No, 22nd of November 2023, my lord.
12th December 2023, we've given them an email where we have stated the amount, my lord, and the calculation. This amount was 1 crore 40
MSME Act. Give the act.
MSME Act.
On the very next day, my lord, 12th December 2023.
Give me that document. Give me that document.
Where's the award?
Award is at page in the 30.
Page 51, sorry, is there page 50, 53. Initial principal amount was 36 lakhs 68,055 rupees.
Page you said?
Page 53, relevant page at which shows the amount, page 61.
Is in AP.
Your Lordship, in AP 575 2023, if your Lordship is looking at AP 578, the award is at page
575.
575. Your Lordship, page 53, an extra K.
757.
757. 757. In AP 757.
Amount is at page 56.
Amount is at page 56.
My lord, there your lordship will find detail. Petitioner's summary until that. They had preferred as per demand
61.
36 lakhs 68,055 rupees. Really, my lord, it was we had given a works contract to them for supply of hospital equipments and maintenance, etc. There was a complete and relevant. Your lordship kindly see page 50 below that a settlement was arrived at between party 18-2.
The petitioner assailed the award dated 12/5/2021. Yes.
Before your Lordship,
Let them deposit the money.
Well, the
Let's clear
money would
matter.
be 2 crore 82 minutes. May I have
Not at
one,
all. Not at all. Whatever
may I
they
only
are
indicate
let it
one
be
judgment which we
deposited,
have
sir.
found, my lord, which says so, my lord. May I only indicate this judgment?
Yes.
My lord, because a conjoint reading of section 16 and section 19 is what we are looking at.
Yes.
Section 16 says the start part, the inception.
Yes.
Section 16 states, may I only take 5 minutes, but I'll try and convince your lordship. Where the buyer fails to make payment of the amount as required under section 15, notwithstanding anything contained in the agreement
Just a
between the
minute.
buyer
Just a
and
minute.
supplier. Section 16.
Just a minute. Yes.
My lord. Where any buyer fails to make payment of the amount to the supplier as required under section 16, buyer shall, notwithstanding anything contained in an agreement between the buyer and the supplier or in any law for the time being enforced, be liable to pay compound interest with monthly rests to the supplier on that amount from the date, from the appointed date, or as the case may be, from the date immediately following the date agreed upon at 3 times the bank rate. So, my lord, the inception is here. Which date? Now, my lord, kindly take up section 19. No application for setting aside of any decree, award, or other order made by either the council itself
or by any institution or center providing alternate dispute resolution services to which reference is made by the council shall be entertained by any court unless the appellant has deposited with it 75% of the amount in terms of the decree. So, my lord, today, when is the date? The question that is before your lordship is, my lord, when is the date when this challenge is made? So, today the challenge, unless and until, my lord, subject to being corrected by your lordship, unless and until they make this payment, there is no section 34 before this honorable court. My lord, Marinecraft, give me Marinecraft's judgment. My lord, there's a judgment of our court where, my lord, this 75% pre-deposit is explained stating that unless this amount is paid, there is no section 34 before the court. Unless this amount is paid. So today, my lord, if there is no section 34 before the honorable court and they want to really argue, my lord, section 36(2), they are on section 36(2), my lord. So today, first step is, my lord, whether there's a section 34 before the court. There's no section 34 because unless and until this payment is made by them. Now, my lord, may I first, Marinecraft. May I first refer to Marinecraft's judgment? Very limited point. Give
The
it.
Supreme Court.
Yes.
I think you're confused between both the issues. We are talking about the deposit of the money.
My lord.
What money has to be deposited? We are not talking about 36(2). This
Indeed.
judgment, Marinecraft talks about the 36 is not bond till the time the 34 amount is deposited.
Indeed. That's my contention for
We are
Marinecraft.
not getting there, sir.
No, now, my lord, kindly take up this judgment of Bharat Heavy Electricals. Give me a copy.
The Supreme Court, my lord.
Please, wait a minute.
Yes, my lord.
This is on an exact similar fact situation, my lord, where there was an award and whether, my lord, this calculation of interest forms a part of the award is decided by the court. Kindly take up, my lord.
Supreme Court judgment to them.
The reasoning of the court, Lord, through the case laws, it starts from paragraph 10. The issue is first called out. The issue, paragraph 10. Since counsel appearing for the petitioner
Read 19, read 19.
19 is, my lord, the final. Yes, my lord. The facts of the instant case seen in the backdrop of the relevant provisions of the Act read together with the case laws on the subject make it clear that the person seeking setting aside of an award must deposit 75% of the award under section 19. The meaning of the expression award must be gleaned from the plain language of the section read with overall object of the MSME Act, which seeks to ensure the survival of the micro, small and medium scale enterprises by formulating the means for realizing the dues of such enterprises from buyers. Section 19 should be construed in a manner which is in consonance with the surrounding provisions, including section 16, which prescribes a special rate of interest and also is aimed at ensuring the economic viability of the micro, small and medium enterprises. In fact, the pro-supplier tilt in section 19 would be evident from the exception in parentheses carved out for suppliers pertaining to the requirement of depositing 75% of the awarded amount. Therefore, reading the expression award in section 19 as confined only to the principal sum and not the interest calculated thereon would amount to a construction which would defeat the very purpose of the Act. After all, if the Socie's rule can be stretched, a provision must take color from the company it keeps. I'm not the next page, GA1.
Yes.
The next paragraph 20.
Yes, yes.
The GA1 is disposed of in view of the above reasons with the direction on the petitioner to deposit 75% comprising of principal sum plus interest as calculated by the chartered accountant 50% and then the procedure, my lord. I am only, my lord, submitting that today in December, my lord, 12th December 2023, we had given this calculation to them. They chose not to make this payment, my lord. Submissions from the bar are being made that we have paid for time because an SLP was preferred. We've never paid for time. That's not, my lord, the reason why, my lord, the matter has been lingering. The reason is, my lord, they have filed a petition.
SLP order also.
They have filed a petition, my lord, for waiving of the 75% pre-deposit, which shows their intention. They never wanted to pay. My lord, that petition is still, my lord, that's GA2. In AP 757. It's an application for waiver of making this pre-deposit of 75%. The award is of 2021. They don't pay till 2026. Calculations have been given in 2023. And now, my lord, they say that we'll pay at the rate which was there in 2023, although we had filed at that time. You had filed without making this pre-deposit consciously. So today, if it was a mistake by them, that's different. My lord, today, they have filed a separate petition contending that I will not be paying the 75% pre-deposit, and they have never withdrawn this.
Sir, why are you arguing this? They have come with the check also.
But I'm not. I'm only on this point that, my lord, the deposit should be, my lord, of 2 crore 82. 75% thereof, because today, my lord, that's the figure. Today, my lord, this amount would be 75% would be 2 crore 11. They are saying it's 2 crore 10. So, my lord, kindly grant them what they are saying. It's 2 crore 10 is what they are saying.
Right.
My lord, kindly grant that. We are okay with it. Lord, we are not.
Make that submission. We are done with it.
2 crore 10. My lord, I'm very grateful. Very grateful.
Should have said.
Sorry, my lord. My lord.
One submission, your lordship only will
First, you
consider.
deposit the money. We'll hear all your submissions. Take down GA2. The petitioner has sealed the order, the award dated. What is the date of the award?
Your lordship, 2 crore 10 is the amount, but 75% is mandated. So we've brought a check
2 crore 82 is the amount. 2 crore 10 is 75%.
Your lordship, we've written accordingly. The total interest computed as on 4th December comes to 2 crores 10, which is in line with the provisions of section 16.
Should I appoint a CA? Should I appoint a CA?
Your lordship, as it falls from your lordship.
What are you saying? Deposit the 75%.
Your lordship, all along, this is the submission they have been. They did not allow us.
Deposit the money. I'm dismissing your GA.
Your lordship.
All right.
Your lordship.
GA will withdraw below that. Your lordship will
Withdraw. Counsel for the petitioner seeks to withdraw the GA2.
Yes, Lord. Lord, one aspect your lordship will consider.
Deposit the money within 2 weeks.
Now, that we are ready, Lord, because the one thing your lordship kindly see, the Honorable Supreme Court, Lord, judgment on both the point, my lord.
Forget the Supreme Court. We will hear it after the 34. This is only for the pre-deposit for the 34 to be admitted. Let the 34 be admitted. We will hear you on merit. We are
Yes,
not on the
Lord.
merits of the matter.
So far, amount should be, Lord, kept in the
Amount is very clear. Award plus the interest. Now calculate that. I'm sure your company has a CA.
We have intimated this by mail.
The only thing what I am urging your lordship will pardon me one, that this amount be Supreme Court says, Lord, we are public undertaking, should be kept in the interest bearing amount. And for that, Lord, I refer only one judgment of the Supreme Court under section 19 itself.
My learned senior knows, my lord, that there's no different footing for any public entity.
We are just requesting it may be deposited in interest bearing account.
Interest bearing. Or GA2 withdrawn. Learn 34 mein likhna. The petitioner is at liberty to deposit 75% of the total amount comprising the principal sum plus the interest. Full stop. The said amount shall be kept. 50% of the amount shall be deposited by the petitioner in cash to the Registrar General original site within 3 weeks.
Your lordship, we have made the demand draft for the entire amount.
The said amount, then demand draft, how will you keep it in the interest
The
bearing?
registrar keeps it, your lordship. He
Registrar
shall deposit the said amount in a with the Registrar General on the of the original site. The same shall be kept into an interest bearing, shall be kept in Spice Bank into an FDR.
Yeah.
Full stop.
Like.
Let this matter be listed for hearing on. We'll keep it after 3 weeks.
May only make a prayer, my lord. Lord, your lordship is very, my lord, very kind to record, my lord, that interest, principal along with interest. May I only pray principal along with interest till date, my lord, because they have, I've just checked, my lord, the demand draft is, my lord, not of the calculation which we have given them.
How much is the demand?
1
crore.
Are you okay with that? Are you okay with that?
I'm praying for 2 crore 10, my lord, till November. Till today, my lord.
Let us start the process. At least let the amount be deposited. We'll see it later. At least 34 will start.
75%, that's not the figure that's coming to 75%. That's my difficulty.
That is the difficulty which you had shown in 2023 also. See the order of 2023.
I've seen.
You were supposed to give them the calculation.
The very next day we have given.
From 20.
The very next
I'm
day.
not getting into it. Whether
I
they are
understand
given, not given, I'm not
Lordship.
concerned.
My lord.
We are sitting in 2026.
Lordship. And they've
All
not made
because
the
of
payment.
both of you.
No, 2026 they've not made the payment till now. That's my difficulty, my
So
lord.
do you want a resolution to this, or you want to just go on with this?
No, we do, my lord, but my only prayer, I leave it to your lordship. My only prayer is this, my lord. Rest I leave it to your lordship.
Discretion is given by the Supreme Court. Honorable High Court has discretion.
Any figure in here.
I understand.
Let them calculate, let
My
them
lord.
deposit.
My lord, I'm very grateful. I understand what is falling from your lordship. I'll bow down.
We are not even looking at it. They'll
I'm very
do a
grateful.
fresh calculation. Let them deposit.
I am very grateful.
75%
I have
of the awarded
followed, my
amount
lord, what's
with
fallen
the
from your
interest.
lordship. Very grateful.
We are not getting into 2 crore 10 lakhs or 2 crore 80
The figure
lakhs.
doesn't, my lord, the order doesn't
It doesn't
mention.
matter, 75%.
Lordship. So, my lord, we can agitate it at a later stage because, my lord, with the calculations will come back. I'm very grateful. Very grateful.
All right, deposit the amount in 3 weeks' time. After 4 weeks, let the matter be listed. 36
very
to only after that.
My lord.
The rest of the matters.
Because my submission in 36.2 would be, my lord, that the entire amount has to be, my lord, then pre-deposited.
That my lord, friend has filed execution case here, Lord, before your lordship. That.
So you deposit the money.
That we have not offered every time only because the court order was not there, so we failed. We have 3 bank drafts we have brought, 3rd bank draft we have brought here.
What condition we are in because of both of you?
third bank draft we have brought before your lordship. Of like this.